within list lordship part heard metal head serial number Delhi में 22-23 में है मैडम, उसको किसी भी समय फिक्स कर दो।
आप शुरू होने देंगे तभी आपका नंबर आएगा, मेंशन मत करिए। हम लोग कोशिश करते हैं जिसका भी केस होता है उसको कम सुन के दो, आपका केस तो नहीं कर सकते ना, यू वेट फॉर सम टाइम।
I will be permitted to mention matter at serial number 64. We have filed an interlocutory application seeking withdrawal of the instant writ petition.
अदर साइड कौन है?
Other side, Mr. Mukesh Kumar is there.
उनको ले आइए, ऑर्डर कर देंगे, 2:15 बजे आ जाइए।
From supplementary list for fresh filing item 1, the LPS 1653 of 2023.
See, I pray for 3 weeks time also.
For what?
Admin council is not present. He is out of state.
3 हफ्ता से बाहर कौन है? आर्गुमेंट काउंसिल जो हाईकोर्ट छोड़ के 3 हफ्ता से बाहर और रहेंगे अगला 3 हफ्ता बाहर।
नहीं, सर्वेंद्र कुमार है, आज नहीं है।
आज नहीं है ना, 3 हफ्ता तक तो नहीं है, ऐसा बात नहीं है ना। कब रखते हैं बताइए, कब वो कोर्ट आ रहे हैं उस दिन बताइए। WPS number 1653 of 2023. Counsel for the petition submits that arguing counsel Mr. Sarvendra Kumar is not available today. He prays that the matter be posted in the next week. Post on Tuesday in the supplementary cause list. काउंटर के लायक भी केस नहीं है, इसीलिए काउंटर कॉल फॉर नहीं कर रहे। बोल दीजिए, पढ़ के आएंगे आराम से फाइनल डिस्पोजल के हिसाब से, सुन के ही काउंटर करेंगे।
Item 2, WPS 1656 of 2023.
Please wait. I'm filing.
You want to withdraw?
Lordship, I cannot withdraw it. Lordship, I had to file it because
I'll do
of some
that.
reason.
WPS number 1656 of 2023. Counsel for the petitioner, Mr. Shreshth Gautam is present. Nobody appears on behalf of the. आप हैं इसमें?
Mr. Ranjan Kumar.
Counsel for the respondents is also present. This writ petition has been filed for the following relief. The perusal of the writ petition reveals that the petitioner is
the son of
the petitioner is son of the employee of the respondent, and he is aggrieved by the transfer of his father. The case of the petitioner is that his mother was not well, and therefore his father ought not to have been transferred. And however, the mother of the petitioner has already expired.
Yes. And it was only after 11 years of his service at one place that he was ordered.
Sorry, that should be sufficient.
Yes, that
The
is sufficient.
son is
And
challenging the order of transfer
also
is too
actually
much.
They were actually disturbed because of this
I
entire
appreciate
venture
that,
because
but,
the lady was. Yes.
We
hence
appreciate
I'm not
the
arguing.
emotions, but law does
Yes,
not permit.
absolutely. Hence I'm not arguing.
I appreciate that, yes. Considering the nature of relief and the aforesaid facts and circumstances that the crisis in the family is already over, this court is not inclined to interfere in the order of transfer, and accordingly this writ petition is dismissed. The law is well settled that the scope of interference in the matter of transfer is very limited.
Item 3, WPS 1941 of 2023.
Mr. Ranjan Kumar has joined online. लिख दीजिए.
If I pray for 2 weeks file for filing substitution also, because the petitioner has expired.
The counsel for the petitioner has submitted that the petitioner has expired, but the cause of action survives. He prays for time to file the substitution petition. He submits that he has already received instructions for the progress. Let the matter be posted on, बताइए date.
4 week at least के बाद कभी भी दे दिया।
इतना 4 हफ्ता आपको
कल हमको-
substitution फाइल करने के लिए चाहिए.
टाइम तो एक दिन लगेगा, हमको परसों ही इन्फॉर्म हुआ है, तो कुछ
देवघर
डॉक्यूमेंट्स लाएंगे तो
क्या डॉक्यूमेंट चाहिए? लीगल हियर्स एंड डेथ सर्टिफिकेट,
डेथ सर्टिफिकेट
राइट?
3 वीक एटलीस्ट, उसके बाद कोई डेट
Posed this case on 16th of April 2024 in the supplementary cause list. In the meantime, the learned counsel for the respondents is directed to seek instruction and file a counter affidavit in this case with particular reference to the grievance raised by the petitioner before the district superintendent of education, wide representation dated 12/6/2018 as contained in page 34 of the petition. इसको देख के बता दीजिए क्या करना है ना? उस दिन ऑर्डर्स में आएगा अंडर द हेडिंग फॉर ऑर्डर्स. अगर आप लगा देंगे रीजन ऑर्डर तो हम केस डिस्पोजल करेंगे
जी, हम कोशिश करेंगे फाइल
और अगर एडवर्स होगा तो इनको लिबर्टी दे देंगे चैलेंज. इसमें नहीं डिसाइड कर पाएंगे.
Item 4, WPS
लेकिन
2267
कोशिश
of
करिए
2023.
कि as per law,
इन द मीन टाइम फाइल हो ही जाएगा.
एज पर लॉ
जी.
कोशिश करिए, थोड़ा उनको यही बताइए कि ये उटपटांग काम नहीं करनी.
जी.
यस पिटिशनर.
Item 4.
Who is for the respondents? CMP.
What we have to say is the impugned order that has been challenged is of 9/5/2014, and after 9 years they have terminated.
The pensioner,
And the second
the
thing-
pensionary benefits and all, they do not become barred by law, barred by time, right?
And the second thing is that they are asking for pension for mother, which is not for which the provisions are not there in our CMPF's pension scheme.
I want to see that. Where is the pension scheme? You've got the pension scheme? Learned counsel for the parties are present. Learned counsel for the respondents. You will also file your counter. The learned counsel for the records of the case reveal that the pension to the mother of deceased ex-employee has been denied only on the ground that mother is not entitled for family pension
As per the scheme.
as per the scheme of 1998. The specific case of the petitioner is that that her son was unmarried and petitioner was fully dependent on her son. Counsel for the respondents are directed to seek instruction and file a counter affidavit in the present case, annexing the copy of the rules on the basis of which the impugned order dated 9/5/2014 is concerned. So far as the delay in filing of the present petition is concerned, the same cannot be a ground to deny the pensionary benefits to the petitioner if the petitioner is otherwise entitled for the same. You file the counter affidavit by 2nd of April. कुछ नहीं करना, आपको खाली स्कीम लगाना है.
एक दिखा एनेक्सर 1 है.
लगाया है क्या इन्होंने?
एनेक्सर 1 पेज 17
क्या है?
सर्विस बुक रिकॉर्ड है.
हाँ
पेज 17.
हाँ.
उसमें नीचे में नामित व्यक्तियों के नाम, तरुणजुआ देवी माँ, वाइफ का नाम काटा हुआ है, फिर सेकंड में फिर वाइफ का नाम काटा हुआ है. ये है.
देखिए, that is not the reason for denial. That is not the reason for denial. If otherwise a mother is entitled for pension, then we will leave it to you to do the necessary inquiries. But we have to find it out. और थोड़ा दूसरा हाईकोर्ट का भी देखिए, कुछ तो कहीं मिलेगा, ऐसा भी नहीं होना. If mother is dependent on the son,
स्कीम में नहीं था इसलिए तो फिर
mother is entitled for maintenance. 125 में मेंटेनेंस तो उनको मिलता है ना.
हम स्कीम के लिए
थोड़ा स्कीम और डिपेंडेंस को थोड़ा देखिए. We may have to interpret that scheme and we will do that.
नहीं और एकदम अगर देना चाहिए.
इसलिए आप इसको 2nd अप्रैल तक आप फाइल कर दीजिए. By 1st अप्रैल तक कर देंगे. by 1st of April 2024, 50th. Oh, sorry, by 1st of May 2024, post on 7th May in the supplementary cause list. आपको कोई जजमेंट नहीं मिला मिस्टर साहनी? होमवर्क नहीं करते आप लोग, सारा होमवर्क हम ही बैठ के करेंगे. This is not proper. Next. नहीं, supplementary cause list में under the same heading. I don't remember the date. कौन सा date?
7th May.
7th.
Item 5, WPS 2285 of 2023.
In this case, prayer is for re-enrollment of the petitioner's home guard membership, as he has been discharged after registration of a criminal case against the petitioner membership. And the present scenario is that the petitioner has already been acquitted from that criminal case.
When were you acquitted?
Yes, Your Lordship.
When were you acquitted?
2019. Case was registered in the year 2018 and acquitted in the year 2019. And thereafter, I have already filed representation before the concerned authorities. And the same has already been forwarded, though, but it has not been decided.
To whom it has been forwarded?
Your Lordship, may kindly see election 4, Your Lordship. जिला समादेश झारखंड के रक्षा वाहिनी.
Respondent number कौन है?
Respondent number
District, respondent number 5. You pass an order on the claim and annex in the counter affidavit. That is a better way. कितना contempt हम लोग सुनते रहेंगे, नहीं सुनेंगे. You pass an order and annex in the counter affidavit. And so far as differential payment is also concerned, you pass an order on that also.
We'll consider whether it can be considered or not, whether it will be reinstated. We'll see if-
There are laws on that.
Yes.
I don't want
But
to say anything.
specific home guard rules, we have to see
You see whatever, you pass an order on that.
immediately.
You can just simply pass an order whether you will retain or not retain and on the whatever representation. And if they have any further claim of differential, etc., they will claim it later. But you just take a decision on that. WPS number 2285 of 2023. The learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner was working as home guard, and on account of a criminal case, the petitioner was discontinued. Discontinued, order of dismissal could pass on.
Your Lordship, though it is not annexed, Your Lordship.
The petitioner was discontinued from service, but the petitioner has not annexed any order regarding discontinuation from service or any order of dismissal. Right? However, from the perusal of the petition, nothing has been mentioned regarding initiation of any departmental proceeding against the petitioner arising out of that criminal case. The learned counsel submits that the petitioner has been acquitted in the criminal case by judgment dated 19th December 2019 and had filed an application before the respondents for taking the petitioner back in service. The same has been forwarded to respondent number 5, but no order has been passed, and therefore the present petition has been filed. The learned counsel for the respondents is directed to seek instructions from respondent number 5 and file a counter affidavit in the present case. If no decision has been taken so far, the decision should also be taken and be annexed along with the counter affidavit. If a decision has already been taken, no fresh decision be passed, and no fresh decision be taken, and the same be simply annexed with the counter affidavit for the records of this case. Do you want a hearing? Do you want a hearing? The petitioner is directed to appear before the respondent number 5 with the records of this case and all relevant documents by filing a representation, and in the representation specific plea, by filing a detailed representation. You file a detailed representation referring to any rules or whatever you want to refer to. On कौन मुकुल थी 15 तारीख को आप हो जाएंगे
15th of April.
हाँ right on 15th of April 2024 at 11 a.m. right. The counter affidavit by the respondent number 5 be filed by 30th April.
Yes, sir.
The petitioner would be entitled for an opportunity of hearing by the respondent number 5 if so demanded by the petitioner in the representation. Post on 1st of May in the supplementary cause list. Next.
Item 6, WPS 2604 of 2023.
In this case is to annexure the order passed by the disciplinary authority and the order passed by the appellate authority. Before inviting to the informed annexures, I submit that the entire proceeding stands vitiated because the state of Bihar, once the cadre of mine has been allocated to the state of Jharkhand, had no authority or jurisdiction to even frame the proposed charges. And based upon that, the charges framed by the state of Bihar, the proceeding stands vitiated. That is the judgment in the case of Arvind Vijay Bilum, taking into account the rule 70, section 73 and section 74 of the Bihar reorganization.
When were you allocated?
Because I was allocated the cadre of the state of Jharkhand in the year 2010 and I joined in the state of Jharkhand on 28/6/2010.
Okay.
And the charges have been framed, that is part of the record that has been framed by the state of Bihar on 16/10/2012. And in terms of the section 73 and 74, once the cadre has been allocated, the state of Jharkhand, state of Bihar is functus officio. So far that part is concerned. Rather, it could have transmitted the records to the state of Jharkhand for
continuation.
Minutes.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner that the entire proceeding is vitiated on account of jurisdictional issues. He submits that the petitioner was allocated Jharkhand cadre in the year 2010 and he joined on 28/6/2010, and the impugned proceeding, including the charge memo, is dated 16/10/2012, issued by the corresponding authority of the state of Bihar.
Minutes.
The learned counsel submits that in view of provisions of section 73 and 74 of Bihar Reorganization Act 2000, after the allocation of cadre of the petitioner to the state of Jharkhand, the authorities in the state of Bihar had no jurisdiction to issue charge memo and conduct disciplinary proceedings. The learned counsel submits that, did you take this point ever?
That is there in the counter affidavit. In the pleadings I have taken this one.
No, I want to know, before the authorities, did you raise this plea?
Because this plea has not.
The learned counsel has fairly submitted that though such plea has not been taken before the disciplinary authority and the appellate authority, but The point being a point of jurisdiction has been specifically raised in the petition and may be considered. The learned counsel for the respondents are directed to seek instruction. Judgment कौन सा बताएंगे?
Arvind Vijay Bulling,
Citation.
Plus I'm just passing on the copies.
The learned counsel for the petitioner has relied upon the judgment passed by the Honorable Supreme Court,
Now, division bench minutes of this honorable court
By-
interpreting 73 minutes.
by
of-
Honorable Division Bench of this court in the case of State of Bihar versus Arvind Vijay Bilung and another, decided way back on 12th of February 2002, and also another judgment on the same point in the case of Umesh Kumar Singh versus State of Jharkhand,
Which has been upheld by the division.
dated 20th September 2006, which has been upheld by the Honorable Division Bench in LPA number 67 of 2007, decided on 18th July 2008. ये अरविंद विजय विलुम का साइटेशन है इसका 2002 SCC ऑनलाइन झार 1118 और ये वाला उमेश कुमार सिंह रिट का साइटेशन है 2006 SCC ऑनलाइन झार 823 एंड डिवीजन बेंच LPA 67 of 2007 का है 2008 SCC ऑनलाइन झार 1110. The learned counsel for the respondents are directed to seek instructions and file a counter affidavit in the present case. The counter affidavit should specifically deal with the aforesaid submissions which has been made by the petitioner and recorded in this case. It's a small point. कितना टाइम लगेगा? 2 हफ्ता बहुत है. इसमें तो काम आपको करना है ना. डिपार्टमेंट क्या काम करेगा?
डिस्ट्रिक्ट से मंगाना है, जाना पड़ता है।
डिस्ट्रिक्ट से नहीं मंगाना है. आपको अपने ढंग के अथॉरिटी से मंगाइए. पूरे बिहार का सवाल है ना, और भी प्रोसीडिंग्स किए होंगे. कौन है रिस्पोंडेंट बताइए.
थ्री एंड फोर से क्योंकि वो प्रपत्र का वही
The counter affidavit in this case should be filed by respondent number 3.
फोर एप्रोप्रिएट है क्योंकि वही से वो लेटर है।
See, it's a matter of interpretation of law and a matter of policy also. Bihar Reorganization Act का interpretation ऐसे नहीं करेंगे. वो अपना चार्जशीट को तो डिफेंड ही करेंगे ना, क्या करेंगे? By respondent number 1 and respondent number 3. Respondent number 1 for State of Jharkhand. एक चीज और लिखिएगा. The learned counsel for the petitioner has submitted that the matter could at best have been remitted to the State of Jharkhand for proceeding, and the State of Bihar could not have initiated the proceeding. Let the counter affidavit be filed by eighth of May. हो गया 4 हफ्ता.
जी
Post on 13th of May in the supplementary cause list. Rejoin local matter है.
Look, rejoinder का कोई आवश्यकता है, legal issue.
चलो next.
Item 7, the replace 2605 of 2023.
The witness number 2605 of 23, a counter affidavit has been filed on behalf of the state. However,
Petitioner did not approach the university or not.
The rejoinder had to file that, but the rejoinder file that, but on that, and the
you
similar
have not
matter-
approached the university for your grievance.
No, sir. The only thing about that, I'm not approached, but the law point is there. But that is
No, no, no. You see, law point, you are seeking a mandamus, no?
Yes.
not seeking
Once
mandamus.
you are seeking a mandamus, you have to approach them
The
first.
similar matter, below the similar matter, below is fixed for final disposal before the coordinate bench, and it is fixed for 8th of May.
I do not know you. Please
Below
don't.
the- And the, in the.
I just want to know from you.
Yes, madam.
You just tell us that without having approached the respondents at any point of time, how do you seek a mandamus from this court?
My lord, because my lord,
Show me some law, I will also see whether a mandamus can be sought for from this court without approaching the authorities for redressal of your grievance. They will consider it, otherwise also they will consider it. I'll give a strict timeline, I'll give you everything.
Yes.
Right? The learned counsel for the parties are present. District petition has been filed for the following relief. A counter affidavit has been filed by the state, wherein it has been mentioned that the matter has to be first taken up by the university. The learned counsel for the respondent university has submitted that though the petitioner is seeking a mandamus, but the petitioner has never approached the university for the redressal of his grievance. He has also assured this court that if the petitioner approaches the respondent number,
Respondent number petition.
5.
respondent number 5, appropriate decision will be taken after hearing the learned counsel for the parties and considering the facts and circumstances of this case. It appears that this court finds that the petitioner is seeking a mandamus, but the grievance of the petitioner has to be first considered by the university. No adverse order has been placed on record by the state. Accordingly, this petition is disposed of, enabling the petitioner to approach respondent number 5 by filing a detailed representation, giving and annexing all the relevant materials which the petitioner seeks to rely upon within a period of by 22nd April?
Yes.
By 22nd April 2024, along with a copy of the deed record and a copy of this order. Upon filing of such representation, the respondent number 5 is directed to grant an opportunity of hearing to the petitioner and pass a reasoned order considering every aspect of the matter which may be raised in the representation of the petitioner by 8th of May 2024, the reasoned order be communicated to the petitioner.
3 weeks.
3 हफ्ता हो गया ना?
नहीं.
अच्छा ठीक. By 15th of May. 15th May. By 15th of May 2024, the reasoned order be communicated to the petitioner through speed post. आप प्रोफेसर हैं?
नहीं तो विद एसोसिएट प्रोफेसर्स के नहीं है नीचे.
ईमेल बोल दें?
मतलब
ईमेल से कम्युनिकेशन चलेगा?
कर सकते हैं.
ठीक.
Provide the email number.
Through email.
As well as the speed post also.
दोनों चाहिए, दोनों नहीं देंगे. Through speed post at the address to be provided by the petitioner in his representation itself. This petition is accordingly disposed of. It is for the respondent number 5 to take into consideration all the applicable law, including rules, regulations, guidelines, etc. And this court has not entered into the merit of the claim of the petitioner. Second case may be same order?
Same order.
Same. Same कहानी है, same order है, same respondent है. Respondent number 5?
Same university भी same.
University.
The counter has not been filed in that.
फाइल है. कैसे बोल रहे हैं
I'm
आप?
not sure about it.
आपको नहीं पता ना? पढ़ते नहीं है फाइल.
मेरे पास हम लोग के ऑफिस का नहीं है।
सेकेंड वाला केस, इसमें भी काउंटर फाइल है.
दूसरा
स्टेट का काउंटर फाइल है.
स्टेट काउंसिल दूसरे.
अच्छा एक बात बताइए, इंसिडेंटली कोई भी केस जब इतना टॉप ऑफ द लिस्ट में रहे तो कम से कम एक बार नेट में चेक तो करना चाहिए ना, बिफोर मेकिंग एनी सबमिशन. किसी का भी हो, यू आर वेस्टिंग द कोर्ट्स टाइम विदाउट वेरीफाइंग द रिकॉर्ड्स. एवरीथिंग इज अवेलेबल टू यू. फोन है, नेट है, आपके पास कंप्यूटर है, चेक करके बोला करिए कोई भी.
Item 9, WPS 2662 of 2023.
Yes, petitioner.
CMPF.
You are for CMPF? Who is for CMPF? बताइए क्या बोलना है?
सिमिलर और सेम ऑर्डर पास हो चुका था इस केस में, एक्सेप्ट फाइल से
देख लीजिए।
इसमें बोकारो धनबाद की जगह बोकारो, ये बोकारो की जगह धनबाद और हम रिप्रेजेंटेशन फाइल किए हैं रिस्पोंडेंट नंबर।
तो धनबाद की जगह बोकारो हो गया, तो आप वहीं पे मॉडिफिकेशन फाइल करेंगे कि नया रीट फाइल करेंगे?
One more thing, this order that he has annexed in annexure 5, the direction was given to respondent number 4. Respondent number 4 will consider the representation. Respondent number 4 was the Commissioner, Coal Mines Provident Fund Officer, Dhanbad. He has not been made a party also in this.
No, but he says that he is not the person who has to consider his representation. He says that it is authority at Bokaro.
Yes,
You should have read the fresh writ then.
Under the provisions of CMPF, does he have a remedy as per the Act?
Also, I have to examine that.
This is the basic thing you could have examined. You examine and come at 250. We'll ask him to proceed before the same authority. We will not pass any order, any direction for making payment. एक बार हो गया आपका गलती, एक बार गलती रेट में करिए, फिर दूसरा रेट फाइल कर दीजिए, ऐसा नहीं होगा. Come at 250, please. You examine, you ask somebody. I think there is a remedy under CMPF. And they need to basically verify the claim and then pass an appropriate order.
Item 10, WPS 2700 of 2023.
It's the matter lead to termination of services of the petitioner. By the impugn order, the petitioner's services have been terminated. And there are two grounds on which I am challenging this very order. Page 37 and issue 10. So there are only two grounds on which I am challenging it. First, the authority who has passed this order, that is the secretary, was not entitled under the provisions of the Act under which the petitioner was appointed in an autonomous body, being a disciplinary authority. The disciplinary authority is the director, it is not the secretary. Secondly, this order that has been passed is a complete non-speaking order which is not addressed to any of the notices and reply given by the petitioner. And if I may just
No show cause was issued to you?
It was issued. It was issued. There was also an inquiry done behind my back.
If he is incompetent, the matter ends.
Sorry, but
If he is not competent, the matter ends.
it ends. If I may just show that one. Just prima facie.
Where is the order?
Let's see, the order is at an issue 10, page 37.
This is one.
This is one. Now, if your lordship will come to the counter,
There
that
is a show cause.
Just a second. Just a second. Annexure 4. Annexure 3 and annexure 4. In Annexure 3, the inquiring officer, the board is appointed, board of inquiry.
The show cause has been issued by the competent authority.
Lordship, if I may just clarify.
No,
if your
no,
lordship-
we
yes,
just,
Lordship.
let's figure it out. The show cause has been issued by the competent
Absolutely.
authority, but the impugned order has been passed by somebody else.
Somebody else.
Were you ever asked to appear before the
No.
authority?
No. Even your lordship, if your lordship would come to Annexure 3, page 29. Page 29, if your lordship is having a look at.
Page 29.
29. Now this is the board which is appointed to inquire against me. Now this appointment is made on 5/8/2022. And kindly turn a page. This is the show cause that is issued to me. That is 3/8/2022. So after the board is appointed, no notice is given to me by the board or the inquiring officer or the inquiring authority. And the inquiry report has also been annexed to the counter affidavit, wherein they say that on this particular date, that is 5/8/2022, there were some questions asked to the petitioner, which he has answered, and on that basis we are coming to a conclusion.
Who's for the respondents?
Mr. GA3 is appearing here.
The learned counsel for the petitioner is present. Nobody appears on behalf of the respondents. The learned counsel for the petitioner submits that notice is required to be issued for two respond number 4 and 5. The learned counsel submits that respond number 4 and 5 are, the learned counsel submits that Jharkhand Nursing Registration Council. Whom are you representing? इनका state का इनका PCC ना for the state. Respond number 1 to 3. The learned counsel for the petition submits that Jharkhand Nurses Registration Council is an autonomous body, and the disciplinary authority is the director.
Yes, sir. The president is the disciplinary authority, and president has been defined as the director.
Okay. President is the disciplinary authority, and the president has been defined as the
Director Health Services Jharkhand.
Director Health Services
Jharkhand.
State of Jharkhand. The learned counsel submits that the impugned order of dismissal or termination.
Termination.
The impugned order of termination of service has been passed by the Joint Secretary.
Yes, sir.
That is respondent number 1.
1.
And he had no jurisdiction to pass the impugned order. The rules, where is that?
It should come to the counter affidavit. Which is at page 16, this act starts from Jharkhand Nurses Registration Act.
The learned counsel submits that the act governing the petitioner has been filed along with the counter affidavit of the respondent number 1
Yes,
at page 16.
yes. And the regulation thereof provides for the dismissal.
Where is the regulation?
Regulation page 39 starts from it.
And the regulation is at page number 39.
And regulation 55 provides for
He has referred to regulation 55 at page
46.
46.
Read with
This has been answered in the counter affidavit.
No, Your Honor, it has not.
Where is your specific plea to this?
So my plea is, Your Honor, that he is not the competent authority.
Yes.
Yes, sir. About paragraph 27 and 28, page 12.
It's too vague a statement.
That is the statement that we have.
Absolutely vague.
29 also.
Vague
that
statement ka vague reply is.
This particular act has not been referred in my writ petition, Your Honor, that I go down. I cannot say that it has been referred in my writ petition. Paragraph 27, also I have just made a statement that respondent number 1 is not the competent authority to terminate the service of the petition.
You have not filed your para-wise comment.
No, Your Honor. In paragraph 25, they have just said about some paragraphs.
जैसा आपका statement है
Oh,
वैसा
वैसा
reply.
ही. I cannot say this thing.
The learned counsel has referred to paragraph 27 and 28 of the writ petition to submit that a plea has been taken that respondent number 1 is not competent authority to terminate the services of the petitioner, but no specific reference to the aforesaid act and the regulations have been
Yes.
made. he submits that no specific response has also come with regard to paragraph 27 and 28 of the writ petition. This court is of the considered view that vague statements made in the writ petition naturally calls for vague reply by the respondents. But considering the point of jurisdiction which has been raised by the petitioner during the course of argument, this court is of the considered view that a supplementary counter affidavit is required to be filed by respondent number 1 to justify the action taken. Let a supplementary counter affidavit be filed by respondent number 1 by 1 तारीख तक, by 1st of May. इतना ऐसा कंफ्यूज्ड क्यों देख रहे हैं, कहीं जा रहे हैं क्या बाहर? हाँ. By 1st of May 2024. In the meantime, the rejoinder, if any, by 15th of May, let notice be issued to respondent number 4 and 5 through speed post, for which requisites be filed by Friday. Office to track speed post delivery. The respondent number 4 and 5 shall also file their counter affidavit prior to next date of hearing. Taking into consideration the aforesaid submission made by the petitioner, the notice should accompany a copy of this order. Post on 15th of May.
If I may also indicate, paragraph 24 and 25 have also made assertions vis-a-vis the inquiring officer or the inquiring committee that was appointed, that no witnesses were examined, nor
बाकी तो आएगा ही.
उस पे भी कोई रिप्लाई नहीं दिया, उस पे भी कोई रिप्लाई नहीं.
उनका कहना है कि कॉन्ट्रैक्चुअल बेसिस पर आपका
कॉन्ट्रैक्चुअल बेसिस
खत्म कर दिया.
लेकिन अगर इंक्वायरी कर रहे हैं तो करना पूरा है, या तो नहीं करें. They may simply sit to terminate me, I am out of the court. But if they are holding me guilty of a particular conduct, then an inquiry is required.
एक चीज और लिखिए. The learned counsel for the petitioner has also submitted that specific averment has been made in paragraph
number 24, 25.
24 and 25 of the writ petition, stating that though an inquiry has been held but no witnesses have been examined,
Nor the petition has been called.
nor the petitioner has been called for,
Yes, sir.
nor the petitioner has been called for, and the respondents have taken a plea in the counter affidavit that the petitioner was working on contractual basis and therefore they have tried to justify the termination of the petitioner. The learned counsel submits that if an inquiry is held on the point by making allegation against the petitioner, the inquiry is taken to is required to be taken to a logical end. And merely by referring to the fact that petitioner was appointed on contractual basis, the petitioner cannot be terminated. Right?
Yes.
15 तारीख. आपका सबमिशन सारा लिखा दिए हैं, उस दिन जजमेंट लिखेंगे. यही रेस्पोंडेंट का यही प्रॉब्लम है, पिटिशनर का भी यही प्रॉब्लम है. वेग स्टेटमेंट देते हैं, उसके बाद पॉइंट ऑफ लॉ पे बहस करते हैं.
Should have been more specific.
Even a point of law is required to be at least one liner that he is not the competent authority and he is the competent authority.
That should have.
इसके बिना दिक्कत है ना.
That should have.
ऐसा point of law हम नहीं decide करते.
I'll make sure that it does not happen.
Because that amounts to violation of principles of natural justice.
Yes. If it is not asserted, then how can it be replied?
Item 11 WPS 2765 of 2023.
Yes, petitioner.
Also, the matter is related to giving me the benefit. As we are all at the LDC, Lower Division Clerk, working under the Forest Department, and there is no promotional and other promotional avenues.
You are working under sanction vacant post?
Yes, we are regular employee. There is no dispute.
No, regular employee.
Yes, and sanction and vacant post. But there is no service condition for their promotion. And the other department, I have annexed the entire document, even the fitment committee, has said that they are entitled for all the benefit as par with the central government, and at par with the central government, other departments are getting all the benefit. There is a hierarchy of the promotions of LDC up to the head clerk and assistant superintendent, which I have stated and annexed all the documents. But
What is the statement in page number 50 bottom?
page number 50.
50. Last line पढ़ी. If such recommendation was given, आगे पढ़ी.
Page 50, Lordship, paragraph 33.
30 पढ़ी.
As per the rule of Executive Business Finance Department has been invested the power to decide the financial matter and every matter which can influence the finance of the state. But it is the Department of Personal Administrative Reform Rajbhasa which should have taken decision or give recommendation over the creation, dissolution of any post. If such recommendation was given by the Department of Personal Reform and Rajbhasa, then how the post creation is pending over 3 pay commission and 18 years? It is a duty of the Department of
I want to
Personal-
know what
Yes,
is this.
this means,
You are
Lordship.
saying that you are working under vacant
And
sanction
sanction.
post.
No, but what I'm saying, Lordship, what my prayer is. And
No, no.
what
Kindly explain this.
Lordship.
There is a mismatch between your submission that they are working under vacant sanction post. Why is there any kind of doubt regarding creation of post?
In para 33, which has been stated for the reason that the further promotion, the post they have to create for other department, they have created LDC to UDC, UDC to head clerk, and head clerk to superintendent, office superintendent. But we are working as a LDC, and still we are LDC. No promotional avenue, nothing, which has to be done by the personal as well as the finance department, because there is a financial implication. So the personal department and finance department, in terms of the fitment committee report, which they say 5th, 6th and 7th revision of pay scale has come, we are still working as a LDC. We have not been given any benefit. For that reason we have said.
So your relief is you are seeking promotion or you are
Promotion,
seeking...
all other benefit as that of the other employees of the state of government are
But
getting.
so far as you are concerned, there is no promotional post created so far.
They have not created any
That's right.
rule
Promotional
as on
post.
date.
Promotional
They have
post.
not created any rule as on date.
You are not governed by these rules.
There is different rule for different department. So far the forest department is concerned, they have not created any rule.
When you were inducted, there was no
10-7-4.
promotional post. At that point of time, there was no promotional post.
No, 10-7-4. We have been inducted as LDC.
10,
In
7,
different
2004.
regional office of Department of Government and Forest Climate Change, and we are all working under
Department of Forest Change. This is under
Forest
Union of
Department.
India or state?
State. They are working in Mufassir or Collectorate.
कहाँ
For
पे
the-
आपका details है?
Yes, I have given detail in paragraph, Lordship. Para 6 onwards, that all the petitioner were appointed from the date 10-7-4 onwards in different regional office.
ये
of the-
different. This is absolutely vague. कहाँ
This
कौन
is
काम
vague.
कर रहे हैं इसका क्या मतलब है? अब सबका पूरा इस तरह से petition बनेगा.
मेरा
ले हम ऐसा डिसाइड नहीं करते हैं किस वेग स्टेटमेंट का कोई मतलब
ठीक है, हम बोल
नहीं.
देते हैं।
कहाँ कौन काम कर रहा है वो आपको बताना पड़ेगा ना.
तो करना होगा. I have been engaged in this case. This is not my. I will ask him to do the same.
धीरे धीरे जूनियर्स लोग को सिखाना पड़ेगा कि
No,
पिटीशन
not-
कि रीड पिटीशन को सीनियर से वेट करा लेना चाहिए. ये नहीं कि जो मर्जी हो सो फाइल कर दी.
नहीं, जूनियर का मेरे ऑफिस का ही केस नहीं है.
आई अप्रिशिएट दैट बट समबडी मस्ट हैव ड्राफ्टेड इट.
हाँ, उनके ऑफिस से हुआ.
क्योंकि अब तो सरिस्ता सिस्टम नहीं है, ट्रेनिंग का कोई कंसेप्ट नहीं है, तो यही सब आता है पिटीशन हम लोग के पास.
ठीक है, इसको
नहीं एक सेकंड. The decision has to be taken by the personal department and the
and
finance
finance
department.
department.
The matter for that decision is pending before them.
Pending. My representation is also pending.
No, your representation ऐसे representation का ये order नहीं होगा.
हाँ, नहीं
decide
नहीं नहीं
होगा.
नहीं होगा.
So now you have to take it is essentially a matter of policy.
Policy.
So you file respondent,
Yes,
you
sir.
file a counter affidavit clearly indicating what do you intend. करना है कि नहीं करना है, नहीं करना है तो लिख दीजिए नहीं करना है, बस बात खत्म, फुल स्टॉप हो जाएगा.
Yes.
लेकिन ऐसा आप वेग नहीं रख सकते, ठीक है? इसीलिए यू हैव टू फाइल रेस्पोंडेंट नंबर 2 और 3 का अलग से एफिडेविट आना चाहिए.
अपॉइंटमेंट लेटर भी तो लोग अनेक से की एक बात है कि स्टेटस का अपॉइंटमेंट किया है, तो पैराग्राफ 6 में एक स्टेटमेंट दिया हुआ है कि on a different dates they have given notes. No appointment letter has been annexed in the entire.
Need not be.
ठीक है, तो हम ले लेते हैं इंस्ट्रक्शन.
आप इंस्ट्रक्शन इट्स अ मैटर ऑफ पॉलिसी एंड इन द मीन टाइम दे विल फाइल अ सप्लीमेंट्री एफिडेविट. आप भेज दीजिएगा उनके
Yes,
पास.
yes.
एक हफ्ता में कर
हाँ,
देंगे.
एकदम कर देंगे.
The learned counsel for the parties are present. This petition has been filed seeking a direction upon the respondents to give all benefits with respect to promotion, higher pay scale and other service benefits which government employees receive during service life as per government rules, notifications and service to respondents. The learned counsel for the petitioners has submitted that the petitioners have been working as lower division clerk in the forest department at different regions within the state of Jharkhand since 10/7/2004, but no promotion has been given to them ever. The learned counsel has further submitted that the reason for not getting any promotion is that no promotional post has been created. He has referred to paragraph number 33 of the writ petition to submit that the decision regarding creation of promotional post is pending for last 18 years and it is a duty of the Department of Personal Administrative Reforms and Rajbhasha to look into the matter. The learned counsel during the course of argument has also submitted that since it has financial implication, the decision has to be taken in consultation with the finance department. The learned counsel submits that so far as other departments are concerned, there are promotional avenues, but the petitioners are deprived of any kind of promotional avenues. However, during the course of argument, it is not in dispute that at the time the petitioner had joined the services, there was no available promotional post for lower division clerk in the forest department. The learned counsel appearing on behalf of the respondents has submitted that the petitioners have not even given the foundational fact regarding their appointment and present place of posting. And he has submitted that only vague statement has been made in paragraph 6 of the writ petition. At this, the learned counsel for the petitioners pray for and is allowed time till 30th April.
Yes,
30th April to annex a copy of the appointment letter of each of the petitioners and also give the details regarding their present place of posting, including their designation. The petitioners should also disclose the present pay scale being paid to the petitioners and as to whether they have been conferred with any financial upgradation during the service period. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit on behalf of
1, 2, 3.
the respondent number 1 to 3 who shall file their counter affidavit in consultation with each other and clearly indicate in the counter affidavit as to whether there is any policy of the state to create promotional post to the for the lower division clerk posted in the forest department. The supplementary affidavit to be filed by the petitioners be also forwarded by the respondent counsel to the respondents for consideration. Let the counter affidavit of respondent number 1 to 3 be filed by 11th of June 2024. Post this case on 12th of June in the supplementary cause list under the heading for admission.
Item 12, WPS 2795 of 2023.
Yes, petitioner.
Have been dismissed from the service by the Annexure 5. My appeal and revision both have been rejected by Annexure 6 and 7. So far as the point involved in the writ petition for my lordship's kind consideration is that there were 8 documents.
Respondents will file your counter. Counter could be required. Yes. Learned counsel for the parties are present. The learned counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case by 8th of May. By 8th of May 2024. Rejoinder, if any, by 14th. By 14th of May. Post on 15th May under the heading for admission. The parties to file their synopsis, list of dates, and the judgments which they seek to rely upon prior to next day.
Item 13, WPS 2880 of 2023.
Mr. Anil Kumar, what we are finding is that in some of the counter affidavits filed by the Union of India, there are certain references made to certain orders, but they are not annexed with the counter.
I'll see to it.
So that is very important. If
Yes,
you are
I'll see
referring
to
to
it.
some circular, etc., you should annex it along
Yes.
counter. Yes.
Lord, Annexure 7 is impugned in this writ petition,
Yes.
which was earlier also impugned by way of an IA in the previous round of writ petition. But I have made a statement in para 2 to the extent that the previous writ petition 43 of 2018 was disposed of in the Lok Adalat. Although, my lord, neither the petitioner nor his counsels were present, but there appears, my lord, in the entire order sheet which I have enclosed to this writ petition.
You have challenged the order of local.
No, my lord, I am not challenging. I am saying, my lord, that our presence is a typographical error indicated in the order sheet. The award is also not signed by the petitioner or his counsel. So, and the IA was never allowed in the previous writ petition. Therefore, my lord, this challenge to Annexure 7 can be maintained. Now, Annexure 7, my lord, what they have done is that I was under suspension for a period. I was punished by the authority in a departmental proceeding, which I challenged before this honorable court. In Annexure 4, my lord, the proceeding was set aside, the order was set aside. A cost of
You file a counter affidavit. The learned counsel for the parties are present. The learned counsel for the respondents is directed to seek instruction and file a counter affidavit by 30th of April. Rejoinder, if any, by थोड़ा और टाइम देते हैं. ये जो लोक अदालत वाला है उसको ठीक से एड्रेस कर लीजिए. ठीक है. Counter by 8th of May 2024. Rejoinder by 16th of May. Post on 12th of June under the heading for admission.
Item 14.
Is it an appealable order? Please address that also. The counter affidavit should clearly
Order
indicate
impugned, my lord. No, that is not.
as to whether the petitioner has any alternative remedy of appeal.
Item 14, WPS 2911 of 2023.
Although I would say, Lordship, that this is not very good, but still I have tried to convince this honorable court. If Lordship may kindly have a look to Annexure 10 for a moment. Annexure 10 is the order impugned before this honorable court in this petition. as a recent order passed by the respondents by which my compassionate appointment application was dismissed. On the ground, Your Lordship, that there has been a judgment of the Honorable Apex Court. That, Your Lordship, the ground of delay has to be considered, and as per the grounds of delay, delay of more than 11 years from the date of.
What is the date of death?
Yes. So what has happened here, Your Lordship? It's a date of it's a civil death. What has happened here? The father of the petitioner was posted, Your Lordship, as minor loader as Lohapatti Kodri Dhanbad. On 28/2008, he went to work, Your Lordship, from his home. He went missing. Thereafter, Your Lordship, Annexure 1, by Annexure 1, page 70, a sana was lodged, Your Lordship, by the mother of the petitioner, Your Lordship, that his husband has gone missing, Your Lordship. And
What is the date of sana?
22/8/2008.
22/8.
The same, 2 days after that, 22/8/2008.
You say that on 28 to.
Yes, 28.
Oh,
Yes,
these
28/2008.
are missing.
He went
And this
missing.
is 22 Sanha.
Yes.
Okay.
Thereafter, by Annexure 2 at page 18, Your Lordship. Now the entire scenario was informed to the respondents, Your Lordship. That is, the representation was
What
made.
is the date?
Date is 23/8/2008.
23/8.
2008.
2008. Respondent informed.
Yes.
Okay, then.
That departmental proceeding was initiated against my husband, Your Lordship, in which also again I represented that my husband is missing. Therefore, the department proceeding will be stopped.
Okay.
That was done by Annexure 3 and 3/1.
Page.
Page 19 to 20.
Date.
Date 27/8/11, and the second application was made on 5/1/2013.
Okay. Then.
Thereafter, Your Lordship, on Annexure 4, the departmental proceeding proceeded ex parte, and and my husband was dismissed from service. By order dated 22/4/2013.
Yes.
Thereafter, Your Lordship, the mother of the petitioner was compelled to file the original suit for declaring him as civil dead. So that was filed, Your Lordship, in the year 2016, being original suit number 266 of 2016.
266.
Of 2016, and the suit was preferred on 9/6/2016.
9/6/16.
2016. Now, at Annexure 5 and 5/1, Your Lordship, the judgment was passed in the suit in the favor of the mother of the petitioner, in which the husband was declared civil dead with effect from 18/12/2017. The judgment 18/12/2017, the date of the decree.
Okay.
So at page 23 to 31, Your Lordship. Thereafter, Your Lordship, after he was declared as civil dead in the year 2017, within the prescribed time limit, that is 18 months, Your Lordship, an application was filed, Your Lordship, for appointment of the petitioner on compassion law. That was done by Annexure 8.
Date.
19/4/19.
19/4.
4/19. Now, when no heed was paid to the application, the petitioner was constrained to move a writ petition, Your Lordship, before this honorable court. That is WPS 1788 of 2020.
1788
Yes.
of
Of 2020.
2020.
Yes. The matter was referred to the National Lok Adalat, and the award was passed by Annexure 9, page 35. Award is on page 35, dated 14/5/2022.
Shall take a decision.
Take a decision.
Decision taken.
Decision taken. Reason order has been passed by Annexure 10. Now let us see the reason order, Your Lordship. Page 36.
Let me just dictate this part of
Yes,
it.
yes.
The learned counsel for the petitioner submits that the father was an employee under the respondents and he went missing on 28/2008. A sana to that effect was lodged with the concerned police station on 22/8/2008, and the respondents were also informed by letter dated 23/8/2008. However, the respondents chose to proceed in departmental proceedings against the father of the petitioner, and during the departmental proceedings also, the mother of the petitioner had informed the respondents by letter dated 27/8/2011 and 5/1/2013 that her husband was missing. In spite of that, the respondents proceeded and passed an order of dismissal ex parte on 22/4/2013. Upon expiry of 7 years from the date of missing of the father of the petitioner, the mother filed original suit number 266 of 2016 on 9/6/2016, which has been decreed by judgment and decree dated 18/12/2017.
Judgment dated is 11/12/17.
Okay.
And decree
Judgment 11/12/17
and decree is 18/12/17.
and decree dated 18/12/2017, and civil death of the father of the petitioner has been declared with effect from 18/12/2017. The learned counsel submits that thereafter the petitioner filed an application for compassionate appointment on 19/4/2019, and when no decision was taken, he filed a writ petition being WPS number 1788 of 2020, which was referred to Lok Adalat and wide award passed in Lok Adalat dated 14/5/2022. The respondent agreed to take a decision in the compassionate appointment, in the claim of compassionate appointment of the petitioner. And thereafter, by the impugned order dated 16/1/2023, the claim has been rejected, which is under challenge in the present procedure. Yes. What is your point? You just come to the point.
Yes. My point is that so far as their written order is concerned, they have relied on the judgment of the Honorable Apex Court that they have also annexed in their counter affidavit. That is in the case of CCL versus Srimati Pardenula.
PARDEN.
Pardenula.
Citation?
Yes. Citation is, Your Worship, civil appeal number is there. They have also annexed the order. If Your Worship may kindly have a look.
Sorry, 2000?
2021
Yes.
SCC online, Supreme Court 299.
299?
Now the grounds they have taken, Your Worship, are
What is
threefold.
your ground?
Yes. First of all, what they have taken, Your Worship, I'll just rebut it, Your Worship, with the judgment of the Honorable Apex Court only. Now, first ground they have taken that there is a policy decision that after civil death, Your Worship, after the person went missing, there is no provision of compassionate appointment. That has been turned on by the Apex Court in the said judgment itself. The judgment they are relying. So that ground is gone. The second ground, Your Worship, that they have taken.
Where is that that finding of the Honorable Supreme Court?
Yes.
That
Yes, Your
in case of civil death.
Yes. Para 9, Your Worship, page 14. We are in agreement with the High Court that the reasons given by the employer for denying compassionate appointment to the respondent's son are not justified. There is no bar in the NCWA for appointment of the son of an employee who has suffered civil death. In addition, merely because the respondent is working. So I'll come to this point later, Your Worship. The first point is that, Your Worship,
You read, please don't read
yes,
half a paragraph.
Yes, Your Worship.
I don't like it.
This is the point supporting me because this particular
But you
judgment.
read also the point which
Yes,
does
yes.
not support you.
Yes. I'm sorry, Your Worship. In addition,
Yes, you read it. I've read it 10 times. You read it.
in addition, merely because the respondent is working, her son cannot be denied compassionate appointment as per the relevant clauses of the National Government Agreement. However, the respondent's husband is missing since 2002. Two sons of the respondent who are the dependents of her husband, as per the records, are also shown as dependents of the respondent. It cannot be said that there was any financial crisis created immediately after respondent's husband went missing in view of the employment of the respondent. Though the reasons given by the employer to deny the relief sought by the respondent are not sustainable, we are convinced that the respondent's son cannot be given compassionate appointment at this point of time. The application
Okay,
for
got it.
yes.
Yes.
This is the main thing, Your Worship, the ground of delay. Now, what I am trying to impress upon this Honorable Court is that, Your Worship, the Honorable Supreme Court, with due respect, has not taken into consideration one fact of the matter, Your Worship, that when a person goes missing, that date should not be considered as a date of death, Your Worship. And so far as the compassionate appointment is concerned, as per the NCWA agreement, The compassionate appointment accrues only when the employee who is in the role of the company dies in harness. So after the death of the employee itself, Your Lordship, the right accrues. It is not a vested right, but the right accrues to at least get consideration. So my point is that, Your Lordship, in this particular judgment,
That at least for 7 years, there is no question of grant of compassionate appointment. At least for 7 years from the date of missing.
yes, for that, Your Lordship, it has to be assessed first whether
That's right, we don't.
the family of the individual
Just a
who
minute.
died.
Yes, what is your case?
First of all, the date of death is not 2017, but it is 2008. Kindly see Annexure 6.
That is the death certificate.
The death certificate.
Death certificate. I was saying so far the degree is concerned. From the degree itself, it is evident that date of death is 2000. Yes, degree. If you watch me, can have a look through Annexure 5. Page 30 onwards. Page 31 is the relevant part.
Yes.
इस प्रकार वादी का यह वाद संघर्ष रूप से डिक्री किया जाता है। वादिनी के पति दीपक दसौंधी पिता सो एंड सो धनबाद को मृत घोषित किया जाता है। तो मृत घोषित किया जाता है फ्रॉम व्हेन? फ्रॉम डेट ऑफ डिक्री। उभय पक्ष मुकदमे के संबंध में अपना अपना खर्च स्वयं वहन। So my point is that, Your Lordship, the date of death ought to have been declared from date of decree. In that context, Your Lordship, one judgment of the Madras High Court is there, if Your Lordship.
मद्रास में पहुंच गए, सुप्रीम कोर्ट नहीं देखते हैं।
नहीं, सुप्रीम कोर्ट का ही
वो हमारा काम है देखना।
नहीं, सुप्रीम कोर्ट का ही रिलाई करके ये किया गया है।
LIC केस।
हाँ, उसी में। तो उसमें बोला गया है कि डेट ऑफ डेथ हैज टू बी
I
रिकॉर्ड।
got special eyes, I can see your judgment.
तो उसमें यही बोला गया है कि the date of death has to be reckoned from the date of decree itself. So decree date is admittedly 2007.
सुप्रीम कोर्ट में ऐसा नहीं बोला है।
नहीं, मद्रास हाई कोर्ट जो बोला है।
मद्रास हाई कोर्ट हमारे ऊपर बाइंडिंग नहीं है।
बाइंडिंग
आपका सुप्रीम कोर्ट
बाइंडिंग नहीं, बाइंडिंग।
सुप्रीम कोर्ट says that the date of death is not declared in a civil death.
It is not declared. But
It cannot be
declared.
declared.
It has to be construed from
No,
that period.
even that has not been said. In that case, the person got missing and he did not deposit the premium.
Yes, premium was not there.
हाँ, यही है ना कहानी।
यही है।
अभी पढ़ ही रहते उसी।
हाँ, यही है। अभी recently आया।
Not in your case, I was reading for some other
ये
case.
अलग-
Recently
अलग-
नहीं आया है, बहुत पुराना judgment।
2021 या 22 का, sorry, 22 का। जो भी हो, that case was on a different grounds.
Anyways,
Lordship,
what
different
do you
facts.
have to say?
Annexure 6 is the death certificate.
Death certificate will not decide, the degree will decide।
No, date of death is A.
आप हमको खाली एक बात बता दीजिए। Date of, there was an ex parte order of dismissal.
Yes,
That is not under challenge.
that is not.
Dismissed employee को कौन सा compassionate appointment मिल सकता है? इतना बहुत है, खाली इतना का जवाब दे दीजिए order।
वो जो इन लोगों का ground ही नहीं है, that is not
Ground.
their ground.
In 226, I am asking you,
Yes.
in a case of a person who is already dismissed, how can you claim a compassionate appointment?
That cannot be claimed, Your Lordship. I bow down to this honorable court.
That
But
is
Your Lordship,
sufficient. That is sufficient to decide this case.
If Your Lordship may kindly appreciate.
In an appropriate case, we'll decide whatever.
That is one of the counts in the recent order.
In the recent order, it is there.
Yes, it is. Kindly come to page 36, Annexure 10, Roman 6. That it is quite clear that on the date of declaration of civil death of the deceased employee, he was not in the roles of the company and was dismissed on 24/2013, and thereby no employer-employee relationship existed on the date of declaration of civil death. And so far as dismissal is concerned, it is in fact 4.
And that date was also prior to expiry of 7 years.
There is one
WPS
other
number 2911 of 2023 में आपको submission इनका लिखा दिया?
point. Apart from it, there was another point.
Not required. जिनका डेथ हो गया है, जिनका डिसमिसल हो गया है, उसको कैसे compassionate appointment मिल सकता है? The learned counsel for the respondents has submitted that as per the recent order and also as per the submissions made by the learned counsel for the petitioner, the order of dismissal, though ex parte, was passed on 22/4/2013. The learned counsel submits that the order of dismissal was passed within 7 years from the date when the father of the petitioner went missing. The learned counsel further submits that the order of dismissal was never challenged by the petitioner or his mother,
May
and in the present case also there is no challenge to the order of dismissal. He submits
I
that
would prefer
once
withdrawal of this
no, I will not permit. Once the he also submits that once the order of dismissal has not been challenged, there is no question of grant of compassionate appointment. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the order of dismissal, though passed ex parte on 22/4/2013 of the father of the petitioner, has attained finality and there is no challenge to the same. In such circumstances, there is no question of grant of compassionate appointment to the petitioner. This court finds that otherwise also the impugned order granting, refusing to grant compassionate appointment to the petitioner is a well-reasoned order. The same does not call for any interference. Accordingly, this petition is hereby dismissed.
liberty even to
No,
challenge that order.
no.
Because that was
I will
there.
record that also. I will not give you any liberty. 2013 का order 2024 में challenge करना है.
That has not been challenged. That is our mistake.
Rightly so. It has attained finality. I have recorded a fact.
Since
It has
not
attained
been challenged,
finality.
obviously it has attained.
आप नहीं challenge हो सकता है. चलिए.
Item 15, WPS 3897 of 2023.
Yes, petitioner.
The litigation in this writ petition, there are two petitioners who are working as night watchman and driver, respectively in the office of SDO and dismissal. Your ladyship, they are
Are you
paying for the
working
rent.
against sanction taken?
There is a specific statement that they are working against sanction payment.
Where is that statement? And since where is your appointment letter?
Madam, it's annexure 1 CPC.
There is a specific time for which you were supposed to work.
That has continued. Our claim is for the point that since we have been appointed since 2001.
Is it 2001 or 2004?
Your Lordship, one of the petitioners is of 2001 and the other is 2000. At page number 25, this is of 2004, and at page number 26, it's of 2001.
25 is petition number 1.
Petition number 1 is page number 20.
This is 29/12/2004. And petitioner number 2?
Petition number is 2 has been working since 5/7/2001. Although they were also in different departments. In regard to petition number 2, we have also annexure 2. They were in different departments. In this department, in the SDO office, they have been working since the annexure 1 year petition. But since before also they have been working. This appointment letter, this letter is in regard to their appointment in the SDO office.
You are still working?
Still working.
From where do you say? From where do you say and what is the proof that you are working?
Annexure number 3 series, your Lordship may kindly see. Although this letter is of 2020 and further.
Just 10 years back.
2020. Annexure 3 series, page number 28. It says Shiv Charan Das ने दिनांक 31/8/2018 से लेकर 2010 तक अनुमंडल कार्यालय सदर चाईबासा में रात्रि प्रहरी के रूप में कार्य किया। इनका कार्य संतोष
यही पीरियड है ना? 2004 से लेकर 2018 तक का क्या कहानी?
This letter of appreciation is of this particular period. Although they have been working in the post of night watchman and driver in different departments.
In different departments or in the same department?
In the same department, in the SDO office. And that
you are making different statements at different point of
Your
time.
Ladyship, they have been working in the SDO office since the advent
Which
of
SDO office?
Your Ladyship, Sadar Chaibasa.
Sadar Chaibasa. So you have filed your application for regularization.
This although
Any
there-
order passed?
No, not yet.
Where is your representation?
There's no representation. That is what I
We can't do anything about it. We will not pass any direction.
Your
You have to
Lordship, I
pursue your
may, be,
remedy.
I may be permitted to approach the department with specific time period
No,
that may be
I will
decided.
not issue a mandamus in a case of this nature. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner number 1 and petitioner number 2 have been working as night watchman and driver in the office of subdivisional subdivisional officer Chaibasa since 29/12/2004, continuously since 29/12/2004 to 5/7/2000 and 5/7/2001 respectively, without any break in service. He submits that the petitioners are entitled for regularization. The learned counsel for the respondents has submitted that the petitioners are seeking mandamus from this court, but they have not approached the respondents at any point of time.
Not
and,
annexed any document in this.
And they have no representation or document has been annexed by the petitioners showing that they had ever approached the respondents for their claim for regularization. The learned counsel has also submitted that the documents placed on record are not sufficient to establish that the petitioners have been working without any break of service since 29/12/2004 and 5/7/2001. He submits that in such circumstances, no mandamus be issued. Considering the aforesaid facts and circumstances, and the fact that the petitioners and the fact that nothing has been placed on record to show that the petitioners have ever approached the respondents for their claim of regularization, though the scheme for regularization has been placed on record in the writ petition. In such circumstances, this court is not inclined to issue any mandamus as prayed for in this writ petition. However, if so advised, the petitioners may approach one or the other respondents for the redressal of their grievance, and this order will not come in the way of the petitioners if they are otherwise entitled for any relief in terms of the policy of the respondents. This petition is accordingly disposed of.
The leadership only to the extent that it may be disposed of expeditiously, nothing more than that. Because I've been working since very long period and they have not taken it.
आपके पास जब क्लाइंट आता है, आप तो एडवोकेट है ना, एक रिप्रेजेंटेशन नहीं दिलवा सकते हैं.
That is the.
So who is there to advise the clients? They should suffer because of your incompetence, isn't it?
Yes, that's true. But only to that extent if I.
Nothing. I have just passed the order.
Item 16, WPS 4432 of 2023.
My lordship, in this case, my lordship, the petitioner is for the payment of the salary, my lordship. My lord, the petitioner is the teacher of the aided school of BCCL, my lordship.
Aided school of BCCL.
BCCL.
How this writ will lie?
My lordship, as per the scheme of the BCCL, my lordship,
बीसीसीएल को पेमेंट नहीं करना है ना?
बीसीसीएल जब एड रिलीज करेंगे तब हमको पेमेंट मिलेगा।
किस स्कूल में काम करते हैं?
तो जो उच्च प्राथमिक विद्यालय जेलगोरा माइनस, ये बीसीसीएल का एडेड स्कूल है। जो इसमें बीसीसीएल एड देते हैं तो हमको सैलरी मिलता है। वही एड जो है सो रोक दिया चाहिए। कारण यही है कि जो प्रिंसिपल जो थे उन पर क्रिमिनल केस हो गया था। क्रिमिनल केस के चलते जो है सो एड रोक दिया गया था।
तो एड रोक दिया तो एड रिलीज करने का ऑर्डर हम नहीं कर सकते। इट मस्ट बी अ पार्ट ऑफ सीएसआर।
बाद में जो इंक्वायरी हुआ, इंक्वायरी होने के बाद जो है सो जब हम इक्विटल हो गए,
This writ petition is not maintainable because they are giving aid to some school and therefore some direction to be issued. They will not.
जो स्कूल जो रनिंग हो रहा था जो एज पर द स्कीम ऑफ द बीसीसीएल, जब बीसीसीएल जब एड दे रहे थे तो उसी के अनुसार
एड बंद कर दिए तो क्या करें?
बंद नहीं किए तो विथहेल्ड करके रखे थे। जो लेटर लगा हुआ है
कहाँ? The school is still working. You are still working in the school.
नहीं, जो हम अभी वर्किंग नहीं कर 2018 तक काम किए हैं। जो उसके बाद पेमेंट नहीं हुआ जो काम हम अभी वर्किंग में नहीं है।
स्कूल बंद हो गया। स्कूल इज क्लोज्ड।
स्कूल तो चल रहा होगा, जो इसमें हम नहीं कह सकते। लेकिन
Why can't you say you are seeking your salary? You don't know whether the school is running or not.
स्कूल तो रनिंग में है, ये होगा ही है। लेकिन प्रिंसिपल डेथ करने के बाद ये भी टीचर लोग वहाँ से हट गए। पेज एनेक्सर 3/1 देखा जाए, जो पेज 19 में जो देखा जाए लास्ट में लिखा है, जो नोट में लिखा हुआ है, उच्च प्राथमिक विद्यालय जेलगोरा पेमेंट टू बी विथहेल्ड टिल फर्दर ऑर्डर आफ्टर नेसेसरी अप्रूवल फ्रॉम द कॉम्पिटेंट अथॉरिटी। विथहेल्ड करके स्टॉप मैंने इस तरह का कुछ नहीं था। विथहेल्ड कर गया था ड्यू टू क्रिमिनल केस अगेंस्ट द प्रिंसिपल ऑफ द स्कूल माइनॉर। और जब बाद में जब हम इक्विटल हो गए जो तो मेरे ही स्कूल का इंक्वायरी हुआ। इंक्वायरी में जब
You were also accused in the criminal case.
नहीं, नो, हम टीचर हैं। जो हमने प्रिंसिपल के अगेंस्ट में था। और इस पे एनेक्सर 4 देखा जाए, जिसमें ये बाद में जब इंक्वायरी हुआ कमेटी के द्वारा, तो फिर जो है सो 16-17 का जो है सो वो एड रिलीज किए और उतना दिन का विथहेल्ड करके रखे। Annexure 4 में permitted to read this matter. A committee is constituted by the office auditor so dated 22/12/2016 issued under the signature of area manager Rotna area as per the instruction of general manager Koila Bhavan hired each with the following executive of Rotna area to verify the status of school by area office for release grant in aid as communicated by the general manager welfare Koila Bhavan hired in letter so and submit report at the earliest area manager so Rotna area are in.
You are claiming the salary from 2010 to 2018.
हाँ, my lord साहब, April 2010 to March 2018 my lord। इतना दिन का रुका हुआ था। इतना दिन हम काम भी किए हैं।
बहुत आप महान हैं। इतना साल काम के बिना पैसे के। ये कहाँ से प्रूव होगा कि आप काम किए?
जो एनेक्सर 1 देखा जाए, मेरा अपॉइंटमेंट जो हुआ था, जो मैंने ये हम जब से काम कर रहे तब से मेरा नाम है।
अपॉइंटमेंट लेटर से नहीं चलेगा ना?
नहीं, अपॉइंटमेंट लेटर नहीं। जो हम जब काम कर रहे थे तो मेरा जब इंक्वायरी कमेटी बना था तो मेरा नाम आया राजू तो उन्हें से काम कर।
Annexure 1 is to 1991.
91 का तो मेरा
I want to know from 2010 to 2018 you have worked. How will it be proved?
तो अटेंडेंस रजिस्टर।
What do you say?
Para 6 of the writ petition.
Yes.
That the petitioner state that the managing committee of the aforesaid school being a private committee had allowed the petitioners casually to join as assistant teachers in the school without issuance of appointment. Casually they had been allowed.
Private company, Jharkhand Education Tribunal. The एक ऑर्डर तो हम भी किए थे।
हाँ जी,
अभी थे।
हम ये किए हुए थे।
तो बताना चाहिए। इनकंसिस्टेंट ऑर्डर कोर्ट से कराने से आपको कोई फायदा नहीं।
इसका कॉलेज का था।
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submit that on account of a criminal case instituted against the principal of the respondent school, in which the petitioners have been working as teachers, the salary of the petitioners were withheld. He submits that the petitioners are claiming salary for the period from 2010 to 2018. He submits that the principal was ultimately acquitted in the criminal case. The learned counsel also submits that the petitioners have throughout worked. The learned counsel for the respondents has submitted that the present writ petition is not maintainable as the relief is essentially against a private school, and he has referred to paragraph, and the petitioners have remedy before Jharkhand Education Tribunal. The learned counsel has also referred to paragraph 6 of the writ petition to submit that the petitioners have themselves stated that the managing committee of the school, being a private committee, had allowed the petitioners casually to join as assistant teacher in the school without issuance of appointment letter. To this, counsel for the petitioners has submitted that the fact that the petitioners have been working is apparent from Annexure 1 to the writ petition. However, he does not dispute, after hearing the learned counsel for the parties and considering the nature of relief prayed for in this writ petition, which is essentially against a private educational institution, this court is not inclined to entertain this writ petition as the petitioner has an efficacious remedy before Jharkhand Education Tribunal. Accordingly, this writ petition is dismissed. The petitioners
dispose of the carrier. But it have jurisdiction, which is changing name of the carrier.
Accordingly, this writ petition is disposed of with the liberty to the petitioner to approach Jharkhand Education Tribunal as may be permissible under law. आपका पूरा claim time बढ़ गया, इसलिए ऐसे ही order करेंगे.
Item 17, WPS 4874 of 2023.
In this case, petitioner is working as a teacher, based on question of annexure.
Annexure
2, and page 28, by which petitioner's pay increment has been stopped. Two pay increment has been stopped.
counterfiled.
But accountant, AG has
You
filed.
filed a
The
counter.
last direction,
That has been
petitioner was
filed.
supposed to file supplementary affidavit.
That has been filed. Annexing all the relevant documents.
You have filed it?
Yes, madam. Inquiry report, the departmental inquiry, the extract, everything has been filed.
जो चीज रिकॉर्ड पे नहीं होगा ना, वो हम कंसिडर नहीं करेंगे. And it will be your responsibility to bring it on record.
Yes, madam. Yes.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that pursuant to order dated 27/2024, all the documents which are relevant for the purposes of adjudication of the present case has been filed. Counsel for the respondent state is directed to seek instruction and file a counter affidavit in the present case by 30th of April. By 8th of May. Rejoinder, if any, by 15th of May. Post this case on 12th of June under the heading for admission. The parties to file their list of dates, synopsis, and the judgments which they seek to rely upon much prior to the next date of hearing.
Item 18, WPS 4974 of 2023.
Yes, petitioner.
Petitioner filed a petition for the shifting to rectify the date of initial appointment as well as the date of promotion of the petitioner manager. A similar case has been decided by this Honorable Coordinate Bench Balance.
What is your prayer?
To rectify and shift the date of initial appointment. And date
What
of
is annexure 4?
Annexure 4.
You are seeking quashing of annexure 4 also. So I want to know what is annexure 4.
They have provisionally they have fixed the payment of this petitioner, and the date they have mentioned of appointment is 1/1/1981 and date of promotion was 1/1/1991. My date of appointment was year 1976, and accordingly they have to set this date of promotion. So they haven't done.
What is the date of promotion? So you want your initial date of appointment to be shifted to 1976 instead of?
Yes, yes.
Instead of?
Instead of 1981.
Any adverse order passed?
No. A similar order has been passed. They are all similarly situated petitioners. Same order will be passed in this case also.
In this case, the university had subsequently passed a rectification order and changed the date of appointment. Is there any such order in your case?
Yes.
Is there any such order in your case?
Yes, yes.
Where is that? Wherein they have changed the initial date of appointment to 1975. Where is that?
It is annexure 6 minutes.
Page number?
Page number 40 to 40.
And where is your name? Surendra. Where is your name in the list?
Serial number 9.
9.
Yes.
55 days is there.
So this is required to be considered. University.
We have already written this to the HRD. I will find my counter. It will be.
You just listen to all. The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner submits that initially that initial date of appointment of the petitioner as lecturer, as professor, the learned counsel submits that the petitioner was initially appointed as lecturer in history in UGC scale by appointment notification number 722/76 dated 18/11/1976 by Bhagalpur University. Now T.M. Bhagalpur University bracket close, and he joined on 19/11/1976 on sanctioned post in History Department of SP College, Dumka, and then under Bhagalpur University, now under Sidhu Kanu Murmu University, Dumka. The services of the petitioner was absorbed by Honorable Chancellor Bihar on 30/12/1918 and was notified by Bhagalpur University by notification number 100/82 dated 12/2/1982. the petitioner was granted time-bound promotion upon completion of 10 years with effect from 19/11/86 by notification dated 10/6/1996 after concurrence from Bihar State University within bracket constituent colleges bracket close commission. And after absorption by the order of the Honorable Chancellor and in view of letter dated 7/8/1989 of Human Resources Department, Government of Bihar, it was observed that the promotions effected or due to the lecturers on or before 1/3/1989 shall not be reopened. The Learned Council submits that the respondent number 3 issued letter number 49 dated 6/3/2003, which was circulated by notification dated 7/3/2003, notifying provisionally, inter alia mentioning the date of appointment of the petitioner as 1/1/1981. There are two petitioners. As 1/1/1981 and date of promotion as 1/1/1991. The Learned Council submits that the university has issued another notification number 88 dated 88/13 dated 17/5/2013, wherein the respondent number 5 has accepted the claim of the petitioner for rectification of the date of appointment. He has referred to Annexure 6 of the writ petition. Page number बताएंगे. Annexure 6 of the writ petition to submit that the name of the petitioner appears at serial number 9 and the rectified date of joining has been stated to be 19/11/1976. The Learned Council submits that on the face of Annexure 6, all the claim of the petitioner, including claim of time-bound promotion, is required to be rectified. The Learned Council has submitted that the petitioner has already represented before the, who will consider your case? State or the university?
We have already listened to the state government for it.
Okay.
So it is ultimately to be decided by the state.
Okay. The Learned Council submits that the petitioner filed representation before the university, who has forwarded the matter to the respondent number 4?
Yes.
Respondent number 4, but no decision has been taken. The Learned Council, registrar की director है ना?
It is referred to the state government director.
Okay. The Learned Council has relied upon judgment passed by this court in WPS number 1362 of 2022 dated 17/10/2023 and has submitted that the petitioner is in the case of the petitioner is squarely covered by the state. The Learned Council for the respondents have submitted that though no counter affidavit has been filed in the present case, and no adverse order as such has been placed on record after the issuance of Annexure 6. Therefore, the claim of the petitioner can be considered by respondent number 4 before whom the matter is pending. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, it appears that at earlier point of time in the year 2003, while Annexure 4, the initial date of appointment of the petitioner was taken as date बताइए 1981
1/1/1981.
as 1/1/1981
Date of appointment and date of promotion was 1/1/1991.
and date of promotion was 1/1/1991, but subsequently another notification has been issued by the respondent university as contained in Annexure 6, wherein the initial date of appointment of the petitioner has been rectified to be 19/11/1976. In view of the aforesaid fact, it prima facie appears that the petitioner is entitled to all consequential reliefs arising out of shifting of the date of initial appointment. But the matter is pending before the respondent number 4, who has to take a decision on the basis of various circulars, guidelines, and applicable rules, including the various orders passed by this court from time to time. Accordingly, this petition is disposed of, enabling the petitioner to approach respondent number 4 by filing a detailed representation within a period of by filing a detailed representation and also annexing copies of the orders of this court which the petitioner seeks to rely upon. The petitioners may also cite the circumstances of similarly situated persons who have been granted the relief as claimed by the petitioner. The respondent number, upon filing of such representation, the respondent number 4 shall pass a reasoned order after granting an opportunity of hearing to the petitioner within a period of 6 weeks from the date of the representation. The
sequential order issued by the university here.
Just the reasoned order be communicated to the petitioner through speed post at the address to be mentioned in the representation itself. The reasoned order be also communicated to the university so that consequential order, if any, be also passed, and the monetary benefit, if any, arising out of the reasoned order be also remitted to the petitioner within a period of 6 months from the date of the reasoned order. However, it is observed that no counter affidavit has been called for in the present case, and it is for the respondent number 4 to pass order in accordance with law, taking into consideration all the applicable guidelines, circulars, etc. of the state government, and also the various orders which may be placed on record by the petitioner.
Yes.
This petition is accordingly disposed of.
Item 19, WPS 6322 of 2023.
Lordship, in fact, in this petition, Lordship, the petitioner for family pension, Lordship. Petitioner is the widow of the employee of the respondent, Lordship, who expired during the service period in the year 2017, Lordship. In fact, all the benefits are, which is entitled, Lordship, already received by this petitioner except the family pension.
Family pension is to be fixed.
My lords, in this case against insurance company, my lords, there were two options, either to take GPF or pension. The husband, my lords, exercised the option for GPF. That has been paid to
How
him.
it can be granted to you?
I have counter not filed, my lords.
But I will just ask
Yes.
you to pass an order and provide it.
Yes, that can be.
Right? That
Yes.
can be done, but I will record your submission
Yes,
on
sir.
instructions.
Yes, I am submitting on instruction.
Yes, the learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner submits that all the post-date benefits of the ex-employee of the respondents who was the husband of the petitioner has been paid except family pension, and therefore the present petition has been made. The learned counsel submits that the petitioner has also filed a representation before the respondent number.
Respondent number Lordship 3.
3 तो है ही नहीं.
Respondent, sorry, 2.
Regional manager is the highest person here.
And SA3 is the representation.
Regional manager,
Chief regional manager, CR.
branch manager इसमें लिखे हैं.
लेकिन representation chief regional manager को दिया.
Before the chief regional manager of the respondent company, though chief regional manager has not been made party in the present proceedings, he submits that no decision has been communicated to the petitioner. The learned counsel for the respondents has submitted that he has received instruction to submit before this court that the ex-employee had opted for GPF by exercising his option during his service period, and in such circumstances, pension is not payable to the petitioner, and GPF has already been paid. The learned counsel has also submitted that since no counter affidavit has been filed in the present case, the chief regional manager shall pass an appropriate order and communicate the same to the petitioner. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, neither any adverse order has been placed on record, and the petitioner, no adverse order has been placed on record, and the petitioner is seeking a mandamus, though being opposed by the respondents on instruction. But this court is of the considered view that the grievance of the petitioner is required to be looked into by the chief regional manager, and if the petitioner is found entitled for any post-death benefit, including family pension, the same is required to be granted to the petitioner. In case the petitioner is not entitled, an appropriate reasoned order be passed and communicated to the petitioner through speed post. The reasoned order be passed on the representation which has been filed. नहीं, आपको एक और representation के लिए बोलेंगे क्या?
ठीक रहेगा मतलब क्योंकि ये
The petitioner the reasoned order be passed upon a representation by the petitioner, upon a detailed representation by the petitioner within a period of 1 month from today.
From the date of
Before the chief manager, and reasoned order will be passed within a period of 1 month. Hearing का कोई काम नहीं अपना पॉलिसी से कर देंगे.
कुछ नहीं
जो है सो दे देंगे बात करते. This petition is accordingly disposed of.
Item 20, WPS 6531 of 2023.
One IA has been filed for amendment in the prayer portion. As Annex 4 is already there in main application, I want to challenge that notification notice. Therefore, IA has been filed for amendment in the prayer by IA number 394.
The learned counsel for the parties are present. IA number 3394 of 2024 has been filed seeking to challenge Annexure 4 to the writ petition, which is already on record. The learned counsel for the petition submits that due to inadvertence, the same could not be challenged. And the petitioner has only prayed for a mandamus. Mandamus का prayer किए थे?
हाँ, amendment कर दिया.
नहीं, ये last sentence है. The learned counsel for the respondents has no serious objection. इसको कभी challenge नहीं किया है ना?
नहीं.
The learned counsel for the petitioner has also submitted that the petitioner has never challenged Annexure 4 in any earlier proceedings. Learned counsel for the respondents has no serious objection to the prayer made after hearing the learned counsel for the parties and considering the nature of relief sought to be introduced through IA number 3394 of 2024. The interlocutory application is allowed. The petitioner is directed to carry out necessary amendments in the writ petition in red ink during the course of the day. Counsel for the respondents is directed to seek instruction and file a counter affidavit to the amended writ petition. To the writ petition as directed to be amended by the petitioner. आप अपने में कर लीजिए simultaneously. इनका मैं भी कर दीजिए. The counter affidavit be filed by 8th of May, rejoinder by 15th, post on 19th June under the heading for admission. In the meantime, the parties to file their list of dates, synopsis, and the judgments which is seek to rely upon. I disclosed.
Item 21, WPL 7257 of 2023.
Yes,
Lordship, on the last occasion, Lordship were directed to file the closure report regarding the case.
Have you filed it?
Yes, Lordship. Lordship, at the very initial stage, I would like to state that my case depends on only one principle of law, that the inquiry that has been done is hit by the principle of personal bias. If your Lordship is convinced that that principle prevails in this case, then only my case stands. Otherwise, I have no other point to.
Who is the, how is it?
Your Lordship, the only thing in the inquiry report is that the person who was responsible for the safety of the father of the petition, he was the member of the inquiry committee which conducted the inquiry. That
the learned counsel for the parties are present. The learned counsel for the petitioner submits that the person who was responsible for the security of the father of the petitioner, safety of the father of the petitioner, was himself a part of the inquiry team. The learned counsel submits that the impugned action, the learned counsel submits that essentially the matter was regarding errors, errors committed by the person who was responsible for the safety of the petitioner, and therefore the impugned action and order suffers from personal bias. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case and produce the records before this court. The इंक्वायरी रिपोर्ट का पूरा रिकॉर्ड प्रोड्यूस कर दीजिए. The counter affidavit be filed by 26th April. क्या करेंगे आप काउंट? आपको तो एक पूरा रिपोर्ट प्रोड्यूस करना है, इतना छोटा सा चीज है. Eighth of May. Ranchi local matter. Rejoinder by 13th, post on 14th. Under the heading for admission.
For admission, item 22, WPL 5898 of 2012.
Yes, petitioner.
Short cost of this is a matter in which award passed in reference case number has been challenged. Though it's a very short matter, it would be proper if we file a short notes of written submissions in this. And the judgment, because there are two judgments which we will be relying, right from the constitutional bench judgment reported in AIR 1964, Supreme Court 477.
Party name?
Party name Sayyid Yaqub versus Radhakrishnan. This is, and thereafter this said was again reiterated in the recent judgment of 2015 volume 4 SCC 270 para 14, and thereafter in 2019 volume 10 SCC page 695. These
Para?
are the last one
Yes.
is a very small. I
That's
don't know the para number.
What is the point involved?
Point involved is that there was a circular issued by the Mrs. Food Corporation of India for regularizing the casual laborers. There were 3 points in that circular. The first was that the laborer should have been
So
working
what is the
before a
point?
cut-
You just,
before a
because we
cutoff
are in,
date. Before a cutoff date.
they do not
he-
satisfy that.
Yeah, I will argue only on one point, and para number 14 of the award, if your readership will go through the para number 14, my entire submission is based on that single para. The concerned workman herein, Ramdeo Das, was not working on that particular day, which is the cutoff date is 2/5/1986. And as per the exhibits, material exhibits W10 and W14, which was produced by the workman before the tribunal, Industrial Tribunal Roman 2 at Dhanbad, it was that he was working from April 1992 to March 1993 in the first slot, and in the second slot it was December 1993 to November 1994. So the entire case of the petitioner demolishes because admittedly he was not fulfilling the criteria of the circular. This is
Who
my
is your
submission.
senior who will argue this case?
Siddharth Roy.
So he was here right now. You want to pass over? Or he wants to do it tomorrow?
At 2:15 or tomorrow?
टाइम आप नहीं चूज कर सकते. पास ओवर हम देते हैं. ठीक है?
इसको कल अगर फाइनल डिस्पोजल में
वो जजमेंट्स देख लीजिएगा. ऑर्डर लिखा रहे हैं, अपलोड कर देंगे, कल तैयारी से आइए. ठीक है? That is better. The learned counsel for the parties are present. The learned counsel for the petitioner seeks adjournment by submitting that Mr. Siddharth Roy is busy in another court. The learned counsel for the respondents has submitted that the entire case revolves around the fact as to whether the petitioner was working on the cutoff date, that is 2/5/1986, for the purposes of seeking regularization. He submits that the petitioner he submits that the respondent had a scheme for regularization for the employees who were working on the cutoff date, that is 2/5/1986. The learned counsel has referred to paragraph 14 of the impugned award and has submitted that the petitioner was working only for the period 492 to 393 and thereafter 1293 to 1194, and in support of which the petitioner had produced two exhibits, W10 and W14.
And those are the casual labor bills of that particular period.
And by producing casual labor bills for this particular period, the learned counsel submits that the petitioner was not entitled for regularization as per the applicable scheme. He has also submitted that the materials on record have been considered, and there being no perversity, the impugned award does not call for any interference. The
Just
learned
one more
counsel.
submission. The concerned workman herein, Ramdeo Das, didn't adduce himself as workman witness to support his submission.
The learned counsel has also submitted that the concerned workman never appeared before the learned court to adduce evidence, and therefore there was no occasion for the respondent to cross-examine the workman with regard to his period of work. Yahi hai aapka?
जी.
The learned counsel has relied upon judgment passed by the Honorable Supreme Court reported in 1964, AIR 1964 SC 477, Para 7, semicolon, bracket 2015, bracket close 4 SCC 270, Para 14, and bracket 2019, bracket close 10 SCC 695. The learned counsel submits that in the subsequent two judgments, the ratio of the judgment passed in the case of AIR 1964 SC 477 has been followed.
Error of law can be corrected in writ of certiorari. Mere error of fact, however grave it is, will not be corrected.
He submits that the judgments are on the point that error of law can be corrected by issuing a writ of certiorari, but under no circumstances the error of fact can be corrected. Perversity पर भी
Perversity होगा तो correct हो सकता है, अगर perversity नहीं होगा तो नहीं.
To this, the learned counsel for the petitioner has submitted that the award can be interfered if it is found perverse. Right? अब perversity खोज के लेके आएंगे. Post this case tomorrow for further hearing. At to be taken up at 2:15. ठीक? मिस्टर सिद्धार्थ रॉय के लिए हम होमवर्क दे दिए हैं, आज ये ऑर्डर अपलोड हो जाएगा. नहीं तो आप YouTube में उनको बोलिएगा सुन लेना. ठीक है?
Item 23, WPS 3218 of 2023.
This case may be tagged with another case, which is 3535 of 23. In fact, there are two persons, both are named as Dumni Hasda. In 3535, there is an interim order passed by this court on 1st August 2023. That is part of our counter affidavit, that is annexed.
We'll tag it. कब करना है? ये तो मेरे ही बोर्ड का है दोनों केस.
Because
you are the same petitioner, same counsel.
No. See, other counsel, there are two persons in the same name. This is with regard to the payment of pension. In the present case, we have
declaration कराना पड़ेगा civil court में जाकर. Who is the actual person?
इस केस में तो हम लोग इन्हीं petitioner को हम लोग बोल रहे हैं कि इनको सारा benefit हम लोग दे चुके हैं.
My instruction as from the bank is also that the account holder is this petitioner.
Yes, sir. So joint account holder is
22 से इन लोगों का ये stay किया हुआ है, बैंक stop कर दिया है payment इन लोगों का pension का.
But this is interim order, we could not.
हाँ, naturally because that
you are paying it to this petitioner.
इसलिए दोनों केस को एक साथ सुनवाई कर लेना ठीक रहेगा.
Right. W दोनों में काउंटर आ गया? काउंटर आया दोनों में?
नहीं, उसमें हम लोग को यूनियन ऑफ इंडिया को पार्टी नहीं बनाया.
उसमें नहीं बनाया गया, उसे पार्टी.
उसमें बैंक पार्टी है और स्टेट गवर्नमेंट को पार्टी बनाती है.
जबकि यूनियन ऑफ इंडिया मिनिस्ट्री पार्टी है.
देखिए WPS नंबर 32 इसका एक ही उपाय है ना. Against indemnity, the payment can continue, and if they get declared through competent court who is the actual wife, then under such circumstances that indemnity can be.
So far as the stand of the department is concerned, they have inquired into and it was found, so far as the present petitioner is concerned, she is the original legal heir of the deceased husband.
We have been paying her.
Okay, the learned
And she
counsel
was
for
being
the
paid all their benefits earlier also.
the learned counsel for the parties are present. The learned counsel for the respondent submit that another person in the same name, that is Domini Hansta, has filed a writ petition being WPC number 3535 of 2023, claiming herself to be the wife of the ex-employee. The learned counsel has submitted that in the said case, Union of India has not been made party, though the bank has been made though the bank and the state of Jharkhand has been made party. He submits that both the cases be tagged and heard together. Counsel for the petitioner has no objection to the prayer made. He submits that the other writ petition has been filed by some other counsel. Considering the aforesaid submissions, pose this case with WPC है?
Yes.
वो C है?
ये सी है,
वो सी है, दूसरा वाला सी है।
C कैसे होगा?
कर दिया
नंबर तो वही किया हुआ उन लोगों ने।
तो C तो यहाँ पे नहीं है। Considering the
with the permission of the
check करिए
justice
तो
I have the order.
C है। Considering the WPC लिखेगा. Considering the fact that WPC is not in the roster of this bench, the office is directed to place this case before the Honorable Chief Justice so that these two matters are placed before appellate bench. उसके ऊपर लिखिएगा, this court is of the view that the present writ petition being WPS number 3218 of 23 is required to be heard with WPC number 3535 of 23.
Yes.
Item 24, WPS 3304 of 2023.
And we see the last one. It's a matter where petitioner is often much marked the last selected candidate, but his candidature was rejected on the ground that he has not submitted the caste certificate in a specific format. JPSC has filed the counter affidavit on 3rd Lords, only few days back. However, the direction was
You want to refine it?
and
File
state
a
has
rejoinder?
not and state has not filed.
Why have you not filed your counter? It is the policy of the state to give reservation to the suitable candidates.
Regarding the central and the state government regulation, I just need more 4 to 5 days your ladyship. I'll file my counter.
You have to compare both the certificates
Yes, your ladyship.
and tell this court as to what is the difference between the two. I could not find any except the heading.
Yes, your
No
ladyship.
matter there is different, that will be explained by the department.
That I'll explain. And it is under process.
And what is the consequence?
Yes, your ladyship.
Right.
I will. It is under process and already we have spoken.
WPS number 3304 of 2023. The learned counsel for the parties are present. The learned counsel for the state prays for and is granted time till 18th of April to file a counter affidavit in the present case in terms of the earlier orders. A counter affidavit of JPSC has already been filed. Counsel for the petitioner, if so advised, may file rejoinder by th of April, pose this case on 1st of May 2024 under the heading for admission.
Few matters have been referred to the larger bench, but which is fixed on 24.
Ram, that is a separate thing altogether.
That in that particular issue
See,
was
if
same.
you want adjournment, I'll give you.
No, I don't want. I just want to apprise your judiciary.
Yes, that is a separate
My
thing. You
lordship
see,
is aware.
we are aware of that.
Yes.
The point is that if this court finds that there is no difference,
Yes.
there is no question of
Yes,
any
yes.
reference to Ram Giroja
Yeah. In
case.
this particular case, there was no cut-off date in that petition, fixed in that.
Wrong.
It is there, wrong, not wrong.
Wrong.
100% right, sir.
We'll see that.
And in the application form, there was no form to mention the caste certificate number. In this particular
A
case.
few orders I have passed, kindly go through it. I will not differ from my.
Yes.
आप LPA फाइल कर रहे हैं कि नहीं कर रहे हैं? अभी एक ऑर्डर किए, क्योंकि अगर कर रहे हैं तो नंबर बताना जरूरी है. Because I must know before repeating the same view. I must know that there is an LPA pending.
In one case, Your Lordship, the order has been passed by my favor. Petitioner has not preferred the appeal. In one case, Your Lordship, that is on different issue, but caste certificate, order has been passed against me. I have sent the department.
Item 25, WPS 3454 of 2023.
Petitioner? File your counter.
My lord, unfortunately it is not filed, my lord. Let it be one more chance be granted, my lord.
Learned counsel for the parties are present. Further time till 8th of May is granted to the respondents to file a counter affidavit. Rejoinder if any by 16th of May. No, rejoinder if any by 11th of June. Post on 19th of June under the heading for admission. The parties to file list of dates, synopsis of arguments, and the judgments which they seek to rely upon much prior to the next date of hearing.
Item 26, WPS 3650 of 2023.
Counter affidavit filed.
Lordship, I'm just being short possible, madam.
I just want to know counter affidavit filed. Yes, petitioner, counter affidavit has been filed in this case.
State government has filed the counter affidavit, but the AG has not filed.
And this one is getting on behalf of AG.
Yes, what is your instructions?
Already, if you letter already issued in favor of petitioner.
बताइए।
I am bringing the copy of it.
दे दीजिए इनको गिफ्ट में। आपको पेंशन पेमेंट ऑर्डर इशू हो गया। शांति?
I obliged my lordship.
दिखाइए कॉपी यहाँ पे। अब आप अपने शब्दों से मत बुक करिएगा। सारे एलिगेशंस खत्म? हो गया? खुश?
I'm extremely sorry, by 21st we could not find the affidavit.
Happy?
because
Petitioner happy?
Yes, my lordship, I am happy.
अब infructuous
My
हो गया
entire
case?
family is based upon this.
Now this case has become infructuous?
No, my lordship, there are more things.
What prayer? More things?
Yes,
what
yes.
prayer?
Yes, just I am going.
Release the pension. वो तो क्या आप क्या आपको सारा
Leave.
आपको surviving
Sanctioning the leave. Now again the question.
No,
This
no.
honorable court has passed in my favor.
Just a moment.
Yes, my lordship.
Let us see the relief. Right? अब आपको पेंशन फिक्स हो गया.
Yes, my lordship.
ठीक?
Yes.
Now earned leave आपका है.
Yes, my
Right?
lordship.
और क्या है? Only earned leave है.
Earned leave and those leave which was granted by the government, the payment has not been made by the respondent.
Just a minute. Who has to make payment for earned leave?
My controlling authority.
Who is your controlling
conservator of the forest, working class.
Who is your respondent number?
Yes, my lordship, just. Respondent number 4 of the main lead petition. Conservator of Forest Working Plan Circuit, Chaibasa, Jamshedpur.
Has he denied you this relief?
No, they are quite mum. They are not
Just
saying
a
anything.
moment.
Yes, my lordship.
You see, now the pension part is over.
Yes, my lordship.
If you have still some grievance regarding quantum, that is a separate cause of action. Right?
IE petition has been filed because
On quantum?
Yes, my lordship.
No, we will not decide the quantum in this case.
Just
Your
a minute.
no.
Just a minute, my lordship.
No.
Just a minute. I was appointed by the Bihar Public Service Commission as the range
We
forest
just
officer.
do not know.
I could not get
So
any.
far as quantum is concerned,
Yeah.
that is a distinct cause of action, and we will not decide it along with the main writ petition.
I will.
IE has been allowed?
No, that is pending.
So therefore that is a separate cause of action. Please appreciate. देखिए जब मल्टीपल कॉज ऑफ एक्शन आपको अच्छे से समझा रहे हैं आप समझिए इस चीज़ को जब मल्टीपल कॉज ऑफ एक्शन एक रिट पिटिशन में क्लब हो जाता है तो कुछ भी क्लियर ऑर्डर नहीं and that creates a lot of problem, right? Therefore, so far as your quantum of pension is concerned, I will give you your liberty and I will not allow your interlocutory application.
Yes.
उसके लिए आपको प्रॉपर रिप्रेजेंटेशन फाइल करना पड़ेगा हर एक पॉइंट को लिखते हुए, और वो लोग अपना देखेंगे तभी यहाँ पर आइएगा.
Only MSCP and SCP has not been granted.
No,
and by promotion,
देखिए आपके लिए AP, ACP और MSCP बोलना बहुत आसान है, लेकिन हम लोग के लिए इतना समझना आसान नहीं है. Unless there is an impugned order, right? So far as your arrears of leave is concerned, we will ask the respondent number 4 to pass an order. Because no adverse order has been placed on record.
Orders has been passed by this honorable court regarding my duty period, and they are stating that I am absent. This honorable court.
He will consider everything.
Yes.
But so far as this, yes.
So far as my lord unauthorized leave is concerned, my lord, para 9 to 13, my lord, you have mentioned in our counter, my lord.
Denying.
My lord, the unauthorized.
Under process, they have stated.
It is under process.
Yes, they have
बताइए
stated.
para number बताइए.
Para, my lord, 10, 11,
10, 11,
12,
12
and 13, my lord.
and 13 of counter affidavit dated.
33, 2013.
Only one counter.
Yes, my lord, 33, 2020.
33, 23.
33, 2024. That has been filed, my lord, pursuant to order dated 21 to 2000.
It is pending before whom? Respond number 4.
4 months considered.
So respond number 4 will ensure pass a
Yes,
final
ma'am.
order.
Yes, ma'am.
If he wants a hearing, we will give him a hearing also.
Yes, ma'am.
Right? There is no ego issue. Whatever is payable, you should pay. Right? Pension will pass an order. अब बस आप बैठ जाइए. देखिए आपकी कहानी खत्म नहीं होने वाली है क्योंकि आपके बहुत सारे डेपुटेशंस पेंडिंग.
The annexer B of the counter affidavit Plea. Annexer B of the page number 19, my lordship. They have treated extraordinary leave. All
वो देखिए, they will pass an order.
Yes, my lordship.
Right? और उसके बाद कोई भी उनका ऑर्डर, कोई भी उनका सर्कुलर जो आपको चैलेंज करना है, वो आपको स्पेसिफिकली चैलेंज करना है. ऐसे नहीं होता. ठीक है? If you want some legal aid, every liberty will be
Yes,
taken.
my lordship. I will be obliged.
Every liberty.
Yes, my lordship.
If there is any order standing against you, you have to challenge it.
Yeah.
In this writ petition, it cannot be considered.
Yes,
okay?
Gratuity they are not paying, but the several orders have been passed, and one I would like to.
Why gratuity has not been paid?
Because of Honorable Supreme Court has passed. D.B. Kapoor versus Jimmy of.
एक second.
Yes.
Why gratuity has not been
Only, my lord, the pension and unutilized leave is there, my lord, 43 C of Pustaka.
This is only for pension and unutilized leave.
Yes, ma'am.
There is no prayer for gratuity.
Counter has also been mentioned for unutilized leave and, my lord, the
Yes.
pension.
Anyways, gratuity का कोई prayer भी नहीं है आपका.
Hi, my lord.
Full payment of pension. अच्छा, one है gratuity.
Yeah.
Gratuity पर भी who will consider for gratuity?
They may not have sent the details, my lord. I believe the state has to clarify. They may have invoked 43C, what I presume.
Yes.
But we have not received the details.
But they have not stated anything about
There
what
are
is the
many
stand
counters.
regarding gratuity.
No, my lord, regarding, my lord, leave and pension is there, stand is taken in the
What is the stand regarding gratuity?
regarding gratuity, my lord.
Who will take a call on gratuity? Just tell us. Who will take a call on gratuity? The same person, respond number 4.
Consider state, my lord, respond number 4 will.
Respond number 4?
Yes, my lord, consider.
The learned counsel for the parties, the petitioner in person and the learned counsel for the respondents are present. This petition has been filed for the following relief. The learned counsel for the respondent number 7 has produced a copy of pension intimation memo dated 27/3/2024, whereby the pension of the petitioner has been fixed with effect from 1/4/2023. A copy of the same is kept on record. He has also furnished a copy of the same to the petitioner appearing in person. The learned counsel for the respondent state has submitted that as per the counter affidavit, paragraph 10 to 13, the matter regarding payment of leave encashment
Yes, ma'am.
is under process and under active consideration of respondent number 4. An appropriate decision will be taken and will be communicated to the petitioner within the time frame as will be fixed by this court. With regard to payment of gratuity, the learned counsel for the respondent state has submitted that an appropriate order in that regard will also be passed in the light of the applicable law. The learned counsel has submitted that the present writ petition be accordingly disposed of. The petitioner in person has submitted that the quantum of pension as has been mentioned in the pension intimation memo is not correct, inasmuch as the petitioner is also entitled for other service benefits like ACP.
MACP.
ACP and?
MACP.
ACP and MACP. He has submitted that he has filed interlocutory application.
Yes, for notional promotion also
For
on the post of ACF
notional
as well as the
promotion.
DA4.
Notional promotion as well as the claim of ACP and MACP. He submits that if the relief as prayed for through the interlocutory application is allowed, not only the pension will be revised, but the petitioner would be also entitled for arrears of salary.
Yes, Madam.
And other consequential reliefs. With regard to that is enough.
One thing, my lordship, Honorable Supreme Court has decided the right to gratuity is also a
The
statutory
learned
right.
counsel submits that so far as gratuity is concerned, it is the statutory right of the petitioner and the same cannot be withheld unless permissible by law.
Only after punishment it can be withheld.
Unless permissible by law should be sufficient.
Yes.
वो आफ्टर पनिशमेंट होगा कि पहले इज अ
Yes.
कंटेस्टेड क्वेश्चन विच वी विल नॉट डिसाइड
I will
विद
go
दिस। आपको ऐसा नहीं सोचना चाहिए कि आप ऐसे जगह पर हैं जहाँ आपकी बात हम लोग नहीं समझ रहे हो।
Yes, madam.
Right? After hearing the learned counsel for the parties and considering the nature of relief as prayed for in this writ petition, this court finds that so far as pension is concerned, the pension intimation memo dated 27/3/2024 has already been issued, entitling the petitioner to receive pension with effect from 1/4/2023. With regard to the quantum of pension, the claim for promotion, ACP and MACP.
Notional promotion on the post of ACF as well as the.
Please have disturbed me.
Yeah, yes, I'm sorry.
Claim for promotion or ACP or MACP. The petitioner has filed interlocutory application. This court is of the considered view that if the interlocutory application is allowed, the same will change the nature of the writ petition, and accordingly this court is not inclined to allow the interlocutory application. However, the right is reserved with the petitioner to take appropriate steps with regard to the reliefs which has been prayed for in the interlocutory application, and also with regard to the quantum of compensation and other consequential reliefs. If the petitioner has any grievance with regard to the quantum of compensation, the quantum of pension. So far as the payment of gratuity and the payment in connection with leave is concerned, so far as payment in connection with leave is concerned, it has been stated in the counter affidavit of the state that the matter is under active consideration of respondent number 4. In such circumstances, the respondent number 4 is required to expedite the matter and take a final decision within a period of 4 weeks from the date of receipt of a copy of this order. The petitioner shall file a representation before respondent number 4, detailed representation, and with supporting documents, and in case the petitioner requires personal hearing, specific prayer be made in the representation itself for such hearing. The order in connection with payment of leave should be a reasoned order. The reasoned order is also required to be communicated to the petitioner through speed post. With regard to payment of gratuity, no adverse order has been placed on record, but the right to receive gratuity is a statutory right, and the same also cannot be withheld unless permissible under law. In such circumstances, the respondent number 4 is also directed to look into the grievance of the petitioner with regard to payment of gratuity.
That will the disciplinary authority and the respondent number 1, the Forest and Environment Department, Additional Chief Secretary of the Forest Department.
At this, the learned counsel, the concerned respondent is required to consider the grievance of the petitioner in connection with payment of gratuity. At this, the counsel for the petitioner has submitted that the appropriate authority would be respondent number 1. For the purposes of grievance regarding payment of gratuity, the petitioner shall file a detailed representation before respondent number 1 with all supporting documents, and the respondent number 1 shall also pass a reasoned order, and if the petitioner prays for any hearing through the representation itself, appropriate opportunity of hearing be also granted to the petitioner. The reasoned order by respondent number 1 be passed within a period of 4 weeks from the date of filing of the representation and be communicated to the petitioner immediately thereafter. If the petitioner is found entitled for any relief pursuant to the reasoned orders to be passed by the respondents, by the aforesaid respondents, appropriate steps be also taken so that the monetary benefit arising out of such reasoned order is also remitted to the petitioner within a period of 4 months from the date of the reasoned order. This writ petition is accordingly disposed of.
One thing. And one thing is that I have committed that under section 340 of the petition that can be.
You remember?
Yeah.
आपने आप भूल सकते हैं, आपने कमिट किया है इसीलिए बस ऐसा नहीं करिए। आप अपना रिटायर कर गए हैं, अपना शांति से रहिए। लाइफ कितना दिन चलता है? 100 साल से ज़्यादा नहीं चलेगा। 100 साल से ज़्यादा लाइफ नहीं चलता है और सरकार हजारों साल चलती है। 340 का कुछ नहीं, बाकी सब खत्म। आपने आईए 340 वाला तो नहीं ना, 340 वाला अलग आईए फाइल किया होगा ना इसमें, वो 340 वाला आईए कर दीजिए क्लोज्ड। हाँ, एक में है इनका अमेंडमेंट, एक में है 340 वाला आईए क्लोज्ड।
Item 27, WPS 4472 of 2023.
Counter has not been filed.
Not filed? There was an order?
There was an
Yes. Counter you have not filed?
In fact, the statement has been received. We have received the statement.
Subsequent recruitment process has begun.
This was so far as that part is concerned, that is not mentioned in the.
आप ना order देख के counter file.
No, the statement which has been given that does not contain that part.
Because the authority has not seen the order.
Yes, but therefore not.
You seek instructions and file counter. WPS number 4472 of 2023. Learned counsel for the learned counsel for the parties are present. The learned counsel for the respondents pray for and is granted further time till 30th April.
Yes.
30th April 2024 to file the counter affidavit in the present case. Post on rejoinder file करना आपको.
because that's the question which have been put to Jharkhand.
Post on 1st of May 24 under the heading for admission. यहाँ से परमिशन लेके फाइल कर दीजिएगा. यहाँ से ना परमिशन लेके फाइल करना पड़ेगा फर्स्ट तक करने.
उसके पहले करो.
Item 28, WPS 4980 of 2023.
Yes. इसमें क्या है?
Period of suspension and the salary has not been given and
there is a provision for passing an order for the period of suspension also at the time of final order in the departmental proceeding. You have been exonerated?
Yeah, the Honorable Dispute has revoked the suspension order and that has been annexed, my lordship.
What is the status? You have filed your counter affidavit?
Yes, sir.
Yes.
You want to file any rejoinder to that?
No need.
Lordship, may I pray, Lordship? Lordship, there are so many facts in this case, Lordship. I have to go through once. It may be kept, I need only 2 days time or it may be kept tomorrow or any day, Lordship. I will.
What is your stand in the counter affidavit?
In
I'll
the
give you
counter,
time.
Lordship, regarding payment, Lordship, you have given a statement in para number 25, Lordship.
Para 25.
Page 25, Lordship.
Yes.
That it is stated and submitted that the order dated so and so passed by this honorable court in the WP number so and so has been duly complied with by the relevant authority as his suspension was revoked by order date number so and so dated so and also of the Department of Forest Environment and Climate Change, Government of Jharkhand. Also, his entire salary due to the petitioner has been paid to him, including substitution allowances to the period and the suspension. That was his prayer in this. And also,
So if the person is ultimately exonerated,
no, he has not been exonerated, Lordship.
where is that order?
Lordship, may kindly see page 8.
Page 8.
This is the list of the proceeding which is concluded.
No, I just want to know, normally whenever any order of punishment is passed, then under such circumstances, the matter regarding subsistence allowance is also there. That whatever has been paid, that will be paid, nothing more will be paid, or whatever.
Also, in para 13, we have given a statement that 6 more department proceeding is still pending against.
So the order of suspension was passed only in one case, I suppose, and the suspension order has been revoked.
Now he is a retired lawyer.
Your period for suspension, which period are you claiming the subsistence allowance? The salary, which period?
Yes, ma'am.
Period?
That has been mentioned in the prayer portion, my lordship, in the main petition.
You prepare a list of dates, that is required. Since he is appearing in person, you have more responsibility to
Yeah, that's why, Lordship, I had prayed, Lordship.
My lordship, please, I want to submit.
You were under judicial custody during that period?
Yes, my lordship, 2 times I was under
On
judicial custody.
account of what kind of allegation?
There are several allegations.
Personal or official?
Mainly the basis of defalcation of the government money. And that was completely false implication. Because
You
of
have been
I
exonerated.
have filed the 4 FIR against the superior authorities. And in retaliation, they have filed a criminal case against me. And suddenly, they have forced to surrender because of
This period from 13th August 2018 to 19 October 2021, all the proceedings which were initiated against you are over?
No. That is from 2010.
Have you been suspended in any other proceeding during this period?
All the suspension matter has been clubbed. The proceeding has been clubbed in a single.
Petitioner has been suspended on 13th August 2028.
And
sorry, 18.
In connection with which departmental proceeding?
That has not been mentioned. That has not been. The
किस
suspension order is
departmental
not a
proceeding
regent
में
order.
आपने उनको किया है and why he should not be? You prepare a note, right?
Please, my lordship, see the next number 34. Honorable, this court has revoked the suspension order, and the classification.
What is the date of revocation of suspension order?
Suspension order after passing this order. Why? The classification control and appeal rule stated after the custody period under sub-rule 2, the period of deemed suspension shall be deemed to end when the government servant gives his joining and the joining shall be accepted. I gave the joining, I submitted my joining report, but they didn't accept it, just they forwarded the joining report and they never paid. They never revoked. And ultimately,
You wait for some time, they will pay.
Yes, my lordship.
If permissible under law.
Before that, please see.
Just आज आपको बोले थे ना, आज आपका सारा केस नहीं करेंगे. आप अपनी बात भूल जाते हैं, लेकिन हम नहीं भूलते. जब तक केस पेंडिंग रहता है, वीडियोग्राफी की तरह याद रहता है. उसके बाद भूल जाते हैं. कल ही आपको बोले थे आज आपका केस हम डिसाइड नहीं करेंगे. सारा काउंटर आ गया?
मेरा काउंटर आ गया.
और किसका काउंटर बाकी है?
नहीं और किसी.
That's it.
ये दो लोगों को
WPS number 4980 of 23. The petitioner in person and the learned counsel for the respondents are present. The learned counsel for the petitioner submits that no rejoinder is required to be filed to the counter.
लॉर्डशिप, इसमें Respondent 5 and 6 has been made party by name.
That has been deleted in the staff reporting section.
The accordingly, the pleading is complete. The parties are directed to file a short synopsis, list of dates, and convenience compilation file करिए. Convenience compilation along with supporting, along with any judgments which they seek to rely upon, and also the extract of the provision of law which they seek to rely upon. दोनों judgments भी file करिएगा, provision of law भी.
मैंने फाइल कर दिया मैलॉर्डशिप.
है क्या? नहीं आपको.
मेरा लगा हुआ है मैलॉर्डशिप. मेरा रिट पिटीशन भी लगा हुआ है. ऑनरेबल दिस कोर्ट हैज रिवोक्ड द सस्पेंशन ऑर्डर.
सुनिए, कन्वीनियंस कंपाइलेशन में उसको एक्सट्रैक्ट के साथ फाइल करना पड़ता है.
मेरे को भी करना है.
आपको मन हो तो करिए, आप कर देते तो अच्छा रहता. हम कन्वीनियंस कंपाइलेशन के डॉक्यूमेंट्स पढ़ के अपना रिसर्च करके आएंगे. आपके सबमिशन पे खाली बहस नहीं सुन सकते. ठीक है? Pose this case on
अठारह को एक केस लगा हुआ है पनिशमेंट ऑर्डर चैलेंज में.
यहाँ पर है.
वो कोर्ट नंबर 7 में मैलॉर्डशिप 18 तारीख को छोड़ कर.
इतना शॉर्ट डेट में नहीं हो.
Maybe 21.
8th of May.
I will be obliged, my lordship.
पहले कर दीजिएगा. जो भी करना फाइल करना है पहले कर दीजिएगा.
For hearing, item 29, the look year 6896 of 2006.
Petitioner.
In this case, the original petitioner, he died, then wife substituted, she also died. Now sons as a, yeah. Just as that he challenged his resignation and has made submission that his resignation was, he submitted his resignation, it was accepted, all the payment without protest, everything clear.
What is the date of resignation?
पेमेंट पर रिसीट भी प्रोड्यूस अंडर प्रोटेस्ट.
आप एक सेकंड, आप बैठिए. आप इनको सुनेंगे ना पहले, उसके बाद आपको सुनेंगे. पहले पिटिशनर से सैटिस्फाइड होंगे तभी आपको सुनेंगे. सैटिस्फाइड नहीं होंगे तो ऐसे ही डिसमिस कर देंगे. ठीक है? इसलिए आप बैठ जाइए.
2895
20/8
His date of appointment is 1157. Date of birth 1139.
Yes, 1157 is
Date of appointment. Date of birth is 1139. And as for date of birth, if taken 60 years, then 4 years, 3 months left from the date of resignation.
What is the date of resignation?
Date of resignation is 2895.
2895. So how much time was left? 4 years?
4 years, 3 months, if 60 years.
3 months. To attain 60 years.
Case is that he applied resignation, date I am giving, he applied resignation stating that his medical health is not good, so he wants to take the resignation. After 1 month, by the Vice President, the resignation was accepted and he was released.
What is the date of acceptance of resignation?
It is Annexure 1.
Not the annexure, you have to show either from the award.
19/7/95.
19/7/95.
And just after 1 month, his letter was accepted and he was released.
Okay.
So, as per, he is giving his date of resignation that prior to 1 month, backdate it has been done. but I will show the annexure 1, that is what is his date of resignation.
According to him, what is his date of
According
resignation?
to him, the date of resignation is 28/95.
And according to you?
It is 97/95, 1 month prior.
You said that the resignation was accepted.
Yes, I will show.
When was it accepted according to you?
After 1 month.
You said, what is it? You just give these dates. According to your case, what is the date of resignation?
97/95.
19/7/95. When was it accepted?
Recommended for immediate acceptance 19/8/95, and on that day he was released.
19/8/95 release. According to him, what is the date of resignation?
19/8/95.
19/8/95. And according to him, it was never accepted. There is no formal acceptance.
It was accepted. He says that it was under coercion. I never applied for resignation. It was under coercion. They called me in the office. 3 persons called me and other persons surrounded me. Under coercion, I have signed on the resignation paper.
His resignation has been exhibited,
Yes.
but he signed on the resignation.
Yes. Annexure 1.
There is another letter dated 19/8/95, which is a resignation letter. Are there two
No,
resignation
one letter.
letters?
One letter. But
You
what-
say it is 19/7/95.
जी एक बार खाली इसको annexure 1 दिखा देना, it will be clear. Annexure 1 of the writ application.
This is exhibit.
Yes. I will come
Exhibit
to the award
number.
also. Just I am giving, I will read the award. Everything I will read the award. Dated, thank you. As I am old patient, Vice President, Mrs. Telco Limited, recommended for immediate acceptance, that date I will read afterwards. As I am an old patient of high blood pressure, I would request you to kindly accept my resignation with immediate effect and relieve me. Thanking you with regards, yours faithfully. This is the petitioner, respondent here. 19/7/95. This is the date of application of the resignation letter. And it was recommended, and the same date was.
Where is your document to show that it was processed on 19/7/95? And what is that exhibit?
Yes. Kindly have a look to the award, tune order under challenge. At page number 9 of the impugn order, page number 9.
This page number 9.
Just the documents I am just having a glance. Exhibit A, third line, is opposite parties letter dated 28 March 1996. That is regarding all the payment and all those things. Exhibit B is carbon copy of appointment letter of the applicant. Exhibit A/1 is opposite party letter dated 13th August 1977. Exhibit A/2 is opposite party letter dated 5th July 1993. Exhibit C is establishment form. Exhibit C/1 is establishment form. Exhibit C/2 is establishment form. All those regarding the payment. Exhibit D is applicant's letter dated 19 July 1991.
Annexure 1 is exhibit D.
जी 19 July 1995.
Okay.
Exhibit C/3 is establishment.
Exhibit D/1.
D, sorry.
D/1 is what?
Applicant letter dated 18 September 1995. Exhibit.
This is annexure.
Annexure. July
Annexure 3.
3.
Annexure 3. This is not applicant's letter. Yes, applicant. Jawaharlal is the applicant.
Jharkhand is the applicant. I'm reading of mine.
Annexure 3. Okay. Exhibit C by 3 is
C by D हो गया. Exhibit D by 1 is applicant's letter dated 18 September
That's right.
1995. The letter written to the
Yes.
authority to take back his
No, this is not the same.
18 September.
18.9 is
Oh, sorry. The 19th August one letter is that your written letter to the authority to. After taking all the payments, he has addressed a letter to the authority.
Exhibit C by 3.
C by 3. Actually,
This
that,
is annexure.
actually that I'm not having with me.
उनका कोई भी डॉक्यूमेंट आपके पास नहीं.
नहीं, इनका ये मेरे पास गवाही है.
गवाही नहीं, डॉक्यूमेंट चाहिए ना. जब आप डॉक्यूमेंट लगा रहे हैं तो फिर सारा ही लगाइए, नहीं तो मत लगाइए कुछ भी, है ना. कहाँ है इनका डॉक्यूमेंट?
इनका डॉक्यूमेंट एग्जिबिट एप्लीकेंट नंबर 1 से है. एप्लीकेंट नंबर 1 का just
19th August 95.
para 19 is the description of his exhibits. Para 19 of the impugn award.
So what do you want to show from this? What is the perversity in the order?
Order, I'm just coming. Two main points. First is on relationship that the one that it will not come under, I will give a judgment on the similar issue, that it will not come under the provision of Bihar Shops and Establishment Act because it is not an establishment, rather it is a manufacturing unit. So it was linked with the manufacturing unit. That's why under the provision of Factories Act it should have been filed. First, your relationship. Second is your relationship that he says that under coercion, I signed on the resignation
If
letter.
it does not come under Bihar Shops and Establishment Act, then the matter would end.
Mentibity that it will not come.
Then he will have a liberty to have appropriate remedy.
For similar
This
issues has been divided.
point was raised before the authority or it was not raised?
It was.
How has it been dealt with?
Yes, I'm coming to that. That's why I said that I will read the award just now. And second issue is that he says that under coercion, resignation letter was signature on the resignation letter was signed. But two things on that issue. Only two issues have been framed by the labor court. That I will come to that afterwards. The issue that he says that under coercion, my submission is.
We'll rise now. We'll continue in the second. ये जब फाइल लीजिए तो ज़रा अवार्ड पढ़ेंगे. At 2:15.